Good morning, all. This appeal hearing is in the matter of CA 008-2025 and is being held by way of video conferencing before His Excellency Chief Justice Wayne Martin, His Excellency Justice Sir Peter Gross, and His Excellency Justice Robert French, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dr. Mahmoud Hussain Advocates and Legal Consultancy. Lead counsels are Ms. Maria Mullah and Mr. Sajid Suleiman. The defendants are represented by Greenberg Tuareg Limited. Lead counsel is Mr. Neil Stewolf. Thank you, Your Honour.
Thank you. Thank you. Ms. Mullah, would you like to commence?
Yes, Your Honours, good morning. I'm Miss Muller, as you know, and I represent the appellants alongside Mr. Suleiman in this case. And this is our appeal following a trial that was heard before His Excellency Lord Justice Glennie in April 2025. And Your Honours can find his judgment at page 177. Your Honours, the point I need to make clear at the very start is that this is an appeal against that judgment and not any other PTA order. And indeed, Your Honour, permission to appeal was granted by Your Honour's order, which we can see at page 3 of the bundle on the 6th of November. And accordingly, counsel prepared amended grounds of appeal, which the court has at page 30 of the bundle. The latest skeleton argument filed on behalf of the appellants is at page 76 of Your Honour's bundle. What I would like to say at the outset is that this is not an appeal that is intended to disturb any findings of fact at all. This is an appeal concerned with serious material omissions, key issues that were simply not addressed as per the grounds in the judgment of His Excellency Lord Justice Glennie. So, Your Honours, at the very start, I think it's important to make that position very clear. Your Honours will know from dealing with this matter that the case arose out of sums that were sought pursuant to the indemnity agreement. And under the indemnity agreement, the UAE federal law is the governing law. And we can see that at page 1024 of the bundle. Oh, that might be a wrong reference. I need to check that reference. But the indemnity agreement had a UAE governing law clause, but it also had a clause that said the DIFC courts have exclusive jurisdiction to determine this matter. How I propose to deal with this appeal, Your Honours, is I shall start with ground 4. I would then like to pass over to Mr. Suleiman, who will deal with grounds 1, 3 and 6, and then I will deal with grounds 5 and 2. At the end of those...
Sorry to interrupt, Ms. Muller. It seems to the court that grounds 1, 3 and 4 rather stand together, don't they? They're all concerned with the finding of deceit. Why are you splitting them up?
Your Honour, it's just how we've dealt with them. I'm happy if Mr. Suleiman wants to start with grounds 1 and 3, and then I can come in and deal with my points on grounds 4, if that assists, if that's better.
I think that would assist the court, because how you use your available time, and on that subject, yes. The court's of the view that each side should have 2 hours for the presentation of oral argument. So we'll work on that basis. But if it helps, the court thinks that the most significant grounds are those grounds dealing with the finding of deceit, which are essentially grounds 1, 3 and 4, and grounds, court's view is grounds 2, 5 and 6 are somewhat peripheral to those grounds. So that, for example, if the grounds relating to deceit succeed, yes, then it may be that it's unnecessary to determine the other grounds. But anyway,
we agree entirely with that approach. So perhaps then Mr. Suleiman can start off with grounds 1 yes. and 3, and then I will finish with ground 4.
Yes, okay, thank you. All right, Mr. Suleiman, over to you.
Thank you. Your Excellencies. If I may then start with ground one and start by going straight to the Civil Code. And then once I've gone through the key provisions in the Civil Code, we can then look at some of the authorities on this, some of the UAE case law on this, and the judge's findings, his lordship's findings at first instance. The Civil Code is at page 1793, please.
Yep. Yes.
Forgive me, my laptop was just playing up. 1793, part 4, which is on the page I'll be going to is 1830.
Yep. Yes.
And if we start, in fact, if we start with 1828, because that sets out the section we're dealing with, I'll just make a brief point on this. We are in part 4 of the Civil Code, which deals with defects in consent.
Yes.
B of part 4 deals with deception and cheating, and that is the section we then turn to at page 1830.
Yes.
Ground 1 concerns Article 185. And I'll just read that out. That is misrepresentation when one of the two contracting parties deceives the other by means of trickery of word or deed, which leads the other to consent to what he would not otherwise have consented to. And tied into that is 187, which is the consequence of that. If one of the contracting parties makes a misrepresentation to the other, and it transpires that the contract was concluded by a gross cheat, the person so misled may cancel the contract. And so what we have there under 185 is a finding, a requirement that firstly, there has to be misrepresentation by one of the two contracting parties. Second part of 185 is that there must be some trickery of word or deed, which leads the other party to consent. And the key part of 187, which I went to, is that there must be a gross cheat. So one of the two contracting parties has to be a gross cheat. And so 185 and 187 have to be both found against the appellant in order for the court to find that the contract can be cancelled.
Mr. Salem, it's put by the respondent that the way these two sections work together is that 185 defines what misrepresentation is, and 187 defines what the consequences may be if the representation is of a sufficiently serious character. Do you accept that general scheme?
As a general scheme, yes. Yeah. That's right, yes.
Yeah,
and I think as I understand what the respondent is focusing on is the gross cheat means there has to be a severity of the, so article, the way yes. We suggest 185 is to be interpreted is that 185 requires an element of deceit or cheating, and 187 requires that to be gross. Yeah. So there's a threshold requirement there before the contract may be cancelled.
Well, I'm sorry, Mr. Salem, but one thing I think the respondent said was that there is no concept of innocent misrepresentation in Dubai law, but the deception is embedded in 185. But then it says it's got nothing to do with the intention of the representor, but simply focuses on the consequences for the representee. That, I think, is the way the respondent puts it. I had in mind their supplementary. I think there's so many skeletons in this case. There's a law of diminishing returns. But I think it's put that way in the supplementary skeleton.
Yes, that's right, yes. And perhaps what I propose to do then is there are 4 key authorities that we rely on, which demonstrate that intent of the representor is a relevant consideration. And perhaps I'll go through each of those 4 in turn.
Thank you.
And I will start with the one at page 2537, please. This is a decision from 2025, and the relevant reference I would take your lordships to is at page 2555.
Yes.
And in particular, the provision that begins halfway down page 2555, where it sets out that it is established that the provision of articles 185, 186, 187, and 191 indicates that deceit is that either contracting party would deceive the other contracting party by verbal or actual fraudulent means that would lead to consent to what it would not otherwise have consented, and that deceit is accompanied by gross unfairness. But then if we go over the page at 2556, and I think this is the point that respondents also refer to, at the top of page 2556, a contract is not dissolved for the mere deceit that is not accompanied by gross unfairness. And it's also not dissolved for gross unfairness unless it's accompanied by deceit by either contracting party or the other one. And then the sentence that I in particular draw to your attention is the sentence that says, that is, it is required to prove both deceit and gross unfairness altogether. And the burden of proving all of this falls upon the opponent that is claiming the deceit. That's the first of the four authorities I'll refer to on this. And the reason I take you to that is that really says that 185 and 187 have to be present at the same time. There has to be both deceit and gross unfairness together. The second authority that I refer your lordships to is at page 2457, please. This is a decision from 2023, and it's in particular 2461 that I refer to. Principle 4 on page 2461. And it's not clear to what extent the respondents take issue with this. But the point made there under principle 4 is that the deceit would require that at the time of contract execution, verbal or actual fraudulent means, and then a few sentences further down, it says fraud consists of two elements, a tangible element and an intangible element. The tangible element is material acts that would cause a contracting party to believe or to confirm a version of the story that is on the contrary to the reality. Whereas the intangible element of fraud is the intention of misleading in order to achieve an illegitimate purpose. If there is no intention to mislead, or if it exists not with the intention to achieve a legitimate purpose, the intangible element of fraud shall not exist and there shall be no deceit. And then it goes on to say it's conditional for the nullification of a contract that fraudulent means used by the contracting party shall be gross. That was the point I made earlier. And so it's quite clear that there are two elements to any finding under 185. And it is the second of the two elements that we say the judge at first instance did not make any finding on. And that is the intent. And if I may, and I think this may, before I go to the remaining authorities on this, if I may just go to the transcript for day 3 at page 1509, please. Page 1509, and it's page 91 within that page. And it's the second half of page 91. This is the transcript from day 3. And Lord Glennie asks, doesn't the word trickery suggest some sort of deliberate misleading, which is very close to, or maybe the same thing as dishonesty? And then the legal representative for the respondent said, it is, Your Honour, and actually, if you could state the position as simple as possible. And so it was not a point in dispute that trickery or deceit requires dishonesty, or there are a number of different ways of looking at this, but there's a mental element or a moral element, as the UAE law puts it. The point which Your Excellencies already have is that there was a finding at first instance that the representation that was made, particularly in relation to whether Mr. Almheiri will be signing the similar indemnity agreement, that it was false. But what we say was absent in any finding, and this perhaps overlaps with ground 3, which we'll turn to in a moment, but what there's an absence of is any finding that the representation which was found to be false was intentionally false or intended to deceive. And the respondent's position, which is to say that a false statement is a lie, I think somewhat misses the point. A lie necessarily involves some element of dishonesty. A lie is a deliberate falsehood, whereas a false statement could be entirely innocently made. And what we say is that the judge made a finding that there was a false statement, not that there was a lie. And nowhere within the judgment is there any finding that a lie was told.
There's no finding, is there, as to the time at which it became known that Mr. Almheiri wasn't going to sign the guarantee?
That's right, yes. There's also no finding on that. Yes, there was some disagreement between the parties as to whether or not there was a finding on that. But it's yes, quite clear that there wasn't a finding.
Well, your client's evidence was that he became aware of it at some time and instructed Mr. Dazi to inform Mr. Cameron of that. That was his evidence, wasn't it?
That's right, yes.
Do we know when that was?
We don't, no. We can check. I don't think we do.
Because, I mean, your point is that there's no finding either that Mr. Dazi knew that Mr. Almheiri wasn't going to sign a guarantee or as to the time. The time could be relevant because if Mr. Dazi is said to be the bearer of the fraudulent intention, and of course that's something that we have to speculate about because there's no specific finding to that effect. But if Mr. Dazi is said to be the person in whom knowledge of the representation and its falsity, and on your case, the dishonest intent reposed, then you need to know whether he was aware that Mr. Almheiri was not going to sign the guarantee at the time he made the representation, or whether he became aware of that subsequently. Because if it's the latter, then questions of misrepresentation by omission would have to be considered. And of course, yes. There's also a question as to whether Mr. Dazi became aware of the position with respect to Mr. Almheiri before or after Mr. Cameron signed the guarantee. Because if it was after.
Yes. What I'll do is I will check the references, whether the time at point at which
yes,
Mr. Almheiri informed Mr. Dazi. What I can say is that the questions surrounding omission or silence under 186 was not something that was pleaded at the first instance, and it wasn't really dealt with in cross-examination of any of the witnesses. And that's perhaps why we have an evidential gap on that point. To the extent that the respondent now wishes to pursue that point, we say that that is a matter for retrial, at which that point can be explored. But at the moment, there is an evidential gap.
Well, while we're on the subject of pleading, I've had a look at the points of claim, but it's not clear to me quite how the respondent pleaded the case with respect to misrepresentation. It seems to be put on the basis that there were representations made with respect to the execution of a guarantee by Mr. Almheiri, the transfer of assets to the special purpose vehicles, and the entry into a lease of those assets to fund the debt to the Qatar National Bank. And then it simply said those things didn't happen. Therefore, there was misrepresentation. Is that impression of the pleading correct, or have I got it wrong?
That's right. That was my understanding as well. And we under ground 3, we say that's one of the reasons why the learned judge's finding is also incorrect, because it proceeds on a similar basis. That certain things were said and then it later transpired they didn't happen. And that is ground 3. Yes, I think that was how it was pleaded. There is also, when I turn to ground 3, I'll look at some of the evidence, Mr. Cameron's evidence in particular. On
well,
this,
is it common ground that there can be no misrepresentation just because a statement about a future event turns out a statement is made about a future event, a predictive statement, and then the prediction turns out to be wrong? It doesn't mean that the prediction was reflects a false statement of fact at the time that it was made, unless you lack the unless it depends upon a state of mind, an implied state of mind as to intention, for example, to do something, and you don't have the intention. And in this case, we seem to have a finding of intention at 43, but it's not clear whose intention it is. But there is this distinction, isn't there, between falsification of a statement about the future, which doesn't necessarily imply misrepresentation, and falsification of a statement of present fact, which might be state of mind or intention, which can imply be a misrepresentation.
Well, that's right. There is it's not a point that the parties agree on. In fact, as I understand, the respondent's position is that under UAE law, there isn't a distinction between present and future facts. But it's unsupported by any authority, and that's the point that we take, that the respondent's position is a position that we couldn't find any authority in UAE law to support. And in fact, the authorities which...
Forgive me interrupting. There is a criticism of the judge that he elided predictive statements, as His Excellency Justice French put it, with statements of present fact.
Yes.
But isn't the problem one which goes beyond the elision, and that is trying to find a conclusion from the judge on the question of intention, which would be needed whether it was a predictive statement or a statement of present fact?
That's right, yes.
It's really a matter of where is the judge's finding on intention, whose intention, and at what time.
Exactly right. And paragraph 43 of the judgment, it's the bit at the bottom of paragraph 43 of the judgment. This is at page 194, please. Page 194, paragraph 43, and it's a bit in the square brackets at the very bottom of the page. It's also curious, it was added in square brackets as though it was not a critical part of the finding. The issue we take there at the very bottom when it said that, namely a representation that as a matter of fact, it was the then intention. There's 3 points we make on that. There's 3 omissions here. The first is, it doesn't identify whose intention was represented. That is, whether it's Mr. Darzi, Mr. Imadi, or Mr. Almheiri. The second, once we address the first point, the second question then is, there's no finding at all here within the judgment that the intention was not held at the time.
Mr. Salem, in the passage that you've taken us to, the last words of the paragraph in parentheses are no point was taken on this. What does the judge mean by was this common ground that these representations of future events could be converted into representations of fact by reference to present intent?
No, that wasn't, and I couldn't see anything in the transcript that suggests that this was in fact discussed. And the other point I'll make related to that, when it says no point was taken on this, is that it doesn't address this different statements that we're dealing with, different representations we're dealing with. In addition to the representation around Mr. Imadi signing the indemnity agreement, there were also representations on the shares under the SPV and the question around leasing of equipment. Nothing at all is said on that, even within that square brackets paragraph we've just looked at. And in fact, we say that that's an even bigger problem because it's just an issue that wasn't, I think, at the fore of the court's mind. And then the third issue we take with this square brackets paragraph is that it doesn't say, or it doesn't make any finding that the representator knew that it was not an intention that was held at the time.
Sorry, can you say it again?
It doesn't. It doesn't. After we overcome the first two obstacles, which is that there's no finding the intention, whose intention was represented. There's no finding that the intention was not in fact held. And it doesn't say that the representor knew that it wasn't held. And that's the intention element of deceit. The representor has to know at the time of making the representation that whoever's intention he was representing, that intention wasn't in fact held at that time. And there's no finding of that in the judgment. I appreciate we're now well into round 3 in terms of my submissions, but they do overlap quite considerably. So I have taken it in that order in answering Your Excellency's questions. If I may then just briefly conclude on ground 1 with the remaining authorities, and I'll take you to those because I think they helpfully confirm the position that the appellant sets out. The next authority I take you to is at page 2425, please. And it's in particular 2426. The reason I'm taking to multiple authorities is I don't know to what extent the respondents take issue with the mental element of deceit. But this authority at 2426, the sentence that begins with the mere lying does not suffice for deceit. Unless it's clearly evidence that the deceived could not have verified the truth in spite of such lying. This we say goes a step further. Lying, firstly, we say is the test, not an untruth. The lying itself requires a mental element, but even lying alone wouldn't be sufficient.
Well, and then you say that's relevant in this case. You say, well, Mr. Cameron could have got in contact with Mr. Almheiri and discovered whether it was in fact his intention to sign a guarantee?
Yes, absolutely. And we say that then also ties into the gross unfairness, which the sentence then goes on to consider. Is that in this case, as they were all business partners and they knew each other very well, it was entirely open to Mr. Cameron to explore some of the statements that had been made and to obtain his own understanding of the position. Yeah. And finally, the final authority I'll take you to on this is at page 2099, please. And in particular, it's 2104. And at the very bottom of 2104, there are 2 paragraphs that begin at the bottom of 2104 and go on to 2105. I'm not proposing to, some of that paragraph deals with 186, the silence that may have been a relevant consideration because, as I said, it wasn't pleaded in the first instance. The perhaps a more important paragraph is 2105, the second paragraph. The paragraph begins with fraud consists of 2 elements. And it says the material element and the moral element, that is the intent to mislead for the purpose of achieving an unlawful aim. And then it goes on to say that the intent to mislead is absent, or if it exists but for the purpose of achieving an unlawful aim, the moral element is absent. The sentence that deals with gross cheat is the sentence that begins with, it's also required for the avoidance of the contract for deceit that the fraudulent means used to be of such gravity as to affect the other contracting party and induce him to conclude the contract. This is the gravity point around gross cheat under 187. And now I've taken Your Excellencies to 4 authorities, all which make the same point, which is that the any finding under Article 185 has to have two aspects to it. And we say the second aspect, the finding of dishonesty or intent to deceive, is entirely absent from the judgment. As my colleague, Ms. Muller, said at the outset, what the respondents now seek to do is refer to aspects of the permission to refusal of permission to appeal by his lordship, where he perhaps adds a little more detail on this. And we say that that isn't court considers. The court considers the judgment on its face.
Well, there is some English authority for the proposition that the respondent cites for the proposition that reasons can be augmented, especially where the appeal is brought on the basis of inadequacy of reasons. But I of course, have looked at the initial application, the refusal of the initial application of permission to appeal, and there are statements in there that, again, seem to lack in particularity. So that, for example, the judge observes that he found that the statements were known to be untrue, but he doesn't say by whom. So I don't think you should assume that you don't have to deal with the respondent's proposition that the findings can be augmented by the statements made in the initial application for permission. But in other words, it might be prudent for you to deal with them and say, well, do they in fact fill the gap, even if they're taken at face value?
Yes, well, to the extent that they do, they don't, in fact, they don't fill the gaps sufficiently. In the criticism that we have, in particular, paragraph 43. Yeah. And in particular, the criticism we have that there's reference to Mr. Ahmadi's signing of the agreement and as to the attention surrounding that. But there's an entire omission surrounding the other two misrepresentations. That is, those concerning the equipment leasing and the shares in the SPVs. That, again, is entirely absent even from the order refusing permission. There's also an absence, again, there is an absence, as Your Excellency has noted, there's an absence of any consideration of whose intention, even in the order refusing permission.
Yes.
And I'll conclude ground one with this. The respondent's own skeleton argument, if I may please take you to that at page 57.
Sorry, which document is this?
This is the respondent's skeleton argument.
Which one?
The 9th of February. I believe this was the first one, I think. So starts at page 53.
Thank you.
And it's dated 9th of February at the very top. And it's paragraph 33 of that skeleton argument.
Yes.
And the reason I take you to this is that it's not clear to me to what extent there's any real disagreement on the test under Article 185. The authority that's cited there, paragraph 33, it goes on to say, below the underlined part, where it says misrepresentations take one of two forms, verbal misrepresentations, which is by mere speech, that is by mere lying, and I emphasize again, lying suggests dishonesty, or actual misrepresentations, which occurs by an act. And then it goes on to say an act from the contracting party which he intends to mislead. And so the intention is very much a critical part of the test in the authority of the respondent cite. Paragraph 34, the second authority of the respondent cite on this, paragraph 34, this is a Court of Cassation decision from 2022. Deceit can take two forms, verbal deceit, and then it says physical deceit, which involves acts intended to mislead the other party. Again, intention is very much a core part of the test.
Sorry, what page was that, the last one?
This is just over the page, page 58.
Yes, thank you.
Paragraph 34, page 58.
Yes.
And so the two authorities cited there by the respondent, both of those do also make the same point that I make by reference to the authorities I cited, which is that intention is a critical part of the two-part test. There's the physical part and the moral part is how it's phrased, the material part, the moral part of the test. And so to the extent that the respondents now take issue with intention being a second of the two limbs, I point to these authorities which the respondent relies on. The wording I think the respondents use, the respondents say intent is embedded in trickery, which I don't think is necessarily wrong. I mean, it's right to the extent that trickery, if that's a synonym of deceit, then it's right that that is embedded within it. But that I think what we're seeking to do is to dissect that test, to say trickery has two aspects to it, and all the case law points to this as two elements to that. And so it is right, it's embedded within it, but it's embedded within it to the extent that it's a two-limb test within what constitutes trickery.
It's the second part of the respondent's proposition that's more difficult, when they say that the test is only concerned with the impact on the representee. That's the point which I think you are really attacking.
Well, exactly right. And I do that by reference to the authorities I cite, but also the respondent cites. And the respondent hasn't actually cited any authority that contradicts the appellant's position on this, that intention of the person making the representation has to be present. And it's difficult to see how any of these authorities cited by the respondent and by the appellants could be interpreted in any other way. And then finally, just a reference from the transcript, page 1420, please. (1420) at the very bottom of the page. This is a cross-examination of Mr. Cameron. At the very bottom of the page, the question that starts with for the documents. The question that was put to Mr. Cameron, you also said that Mr. Al-Raj and Mr. Dazi were out to trick you in relation to that. And he says, well, I didn't say that. And then the follow-up question is, well, is your answer no then? You are not saying they were trying to trick you. And he says, no. And so what we say is the relevance of this is that if the legal test is that there has to be an element of trying to trick, that there is an intentional aspect of this, then Mr. Cameron's own evidence was that they weren't trying to trick him.
Mr. Salem, if you read on,
yes,
it becomes rather less clear, doesn't it?
It does, but I think the reason the question was put in that way was to try and understand what he understood was the intentions of the parties. But I only take you to that to make the point. To the extent
you're going to win on that point, are you?
No. I only take you to that just to show that it was a point explored at trial, and the appellant's position always was that intention was a relevant aspect of the test, and that's why the questions were phrased in the way that they were. Unless I can assist any further on ground one, I will then turn to ground three.
Thank you.
Thank you. Ground three, which is the point we've already discussed, in fact, at some length. And then that is really a question of whether paragraph 43 of the judgment and the bit in the square brackets is a correct approach, legally the correct approach. And it makes all the findings that were required to be made. I've already addressed you as to the three issues we take with that. And perhaps the one authority that's helpful here is at page 2461. Forgive me, my laptop is playing up. Page 2461, forgive me, my laptop is playing up, but it's the authority that I referred to earlier. And the point taken there is that the intention to mislead has to exist at the point of contracting.
just to help, that is halfway down that page.
Thank you. Thank you very much.
Well,
Yes.
it's like the fifth line down where it says at the time of contract execution.
Yeah, thank you, Ms. Miller. Yes,
Halfway up page 2461, is it?
that's right, yes.
Yes, thank you.
Forgive me, I may have to manually
Yes,
scroll
yes.
down. My search function isn't working. But yes, 2461.
Yes, the deceit that renders. Well, I mean, that must mean surely at the time of contract execution, that must mean representations made prior to contract execution, doesn't it?
Yes, yes, prior to or at the time of, it would suggest, but it's not future. Yes.
Yes. Yes, all right.
Yes, and the other reference that may be helpful here is Mr. Cameron's own evidence at page 1477, please. It begins at page 1476 at the very bottom, but at the top of page 1477. And this answers Your Excellency's earlier question about the representation that it was suggested had been made. And he said the key representations that motivated me to move forward with this opportunity were, one, that the loan would be procured by Khaled Almheiri, which he did do, and the loans would be serviced by equipment leases of the two companies, and that there would be guarantees issued by myself, Mr. Al-Araj, and Mr. Al-Imadi on the same terms and conditions that we would receive shares in the business. And the third point is the shares in the business. This is, as Your Excellency said, this was also the pleaded case. These are the three representations that we are concerned with. And as I already said, the two of those, that is around the shares and the leasing of equipment, was something that the judge in paragraph 43 didn't make any finding as to intentions, parties, whose intentions, whether they were false at the time, and whether the person making the representations knew that they were false. It's a curious absence from the judgment that for the shares, it would need to be clear whose intention it was that there would be a share allocation and who whether that intention was false at the time it was made. I've made the point, and I think you have the point. The judgment just doesn't address that at all. I think what it does in the square brackets is it refers to Mr. Imadi's the paragraph 43 square brackets. It refers to the issue surrounding one of the three alleged misrepresentations, Mr. Imadi signing the statement. And it appears to just treat that as being the critical misrepresentation.
Well, should we then construe the judgment on the basis that he did not make findings that the other representations were fraudulent, or how do we deal with it?
Well, there's no finding on that, so we would suggest that there isn't any finding that those representations were false or that they were intended to mislead.
Right.
There's just a wholesale absence of any consideration of that. I've already addressed ground three, I think, initially at the outset, following your questions. Unless there's anything I can address you on any further on that, no. I'll conclude ground three there, and I'll hand back over to Ms. Muller for ground four.
Thank you. Ms. Muller, ground four.
Thank you. This is a very straightforward ground in my respectful submission. We now come on to Article 190, and ground four is all based on the fact that the judge did not address and failed to address the question raised by Article 190, which requires actual knowledge of the contracting party. So if we have a look at Article 190, and that's at page 1830 of the bundle. And it states if the misrepresentation is made by a person other than the contracting parties, and the person to whom the misrepresentation was made proves that the other contracting party knew of the misrepresentation, it shall be permissible for him to cancel the contract. As we know from the judgment, and if we go back to paragraph 56 at page 198 of the judgment, it is said here quite clearly by the judge, that is not to say that the claimant knew that a false representation was being made, but that is not the question. Well, we know, pausing there, that under Article 190, that clearly is a fundamental question.
Well,
Going
Ms.
back
Muller,
to-
it's fundamental if 190 is the basis of liability, but what do you say to the proposition that the respondent advances to the effect that the judge was working on the basis that he had found ostensible authority, that is, that Mr. Darzi had the ostensible authority of Mr. Almheiri, so that anything that Mr. Darzi said was as if said by Mr. Almheiri, and therefore it was 185 and 187 that were applicable, not 190.
Well, I will say, and I submit quite clearly, 190 is a statutory route for a non-contracting party, and that is the clear route. And the respondents rely on
even if, so you say it applies even if it is a statement made by somebody, an agent acting within the scope of the authority of the principal. You've still got to bring yourself within 190.
Yes, because
is there authority for that? Do you have authority for that?
No, and Your Excellency, the respondents have not provided any authorities which show any circumstances where a party acting as an agent makes representations or misrepresentations and can fall within Articles 185 to 187. They provided no authorities which support that proposition. But most importantly, fundamentally in this case as well, whilst the judge did find that effectively it was stated that the claimant put Mr. Darzi in a position of speaking for him, and he said the false representation made by Mr. Darzi can be treated as though made by the claimant. There was no exploration by the judge of any of the evidence that he referred to make this finding of the false representation by Darzi being treated as being made by the claimant. But most importantly as well, there was a complete failure to refer to any UAE principles of law as to how he had reached that conclusion. And that was quite an omission from the judgment.
Didn't he say that Darzi was reporting to that Almheiri was telling Darzi what to do and that Darzi was reporting to him?
He did, yes, but in the judgment there was no real evidence of that, and the evidence in fact pointed, and the court may be aware from the transcript, there was some question that in fact Darzi was acting on behalf of all the UBOs and was even being paid by Mr. Ahmadi to keep everybody in the picture. So the establishment of this agency relationship, it's not clear how the judges got there. Firstly, there's been no assessment or analysis of the evidence which he's considered and found that agency relationship is established. And secondly, he fails to set out any of the legal principles that he's taken to get to that position and what UAE principle of law he relies on to demonstrate this agency relationship. So I say there's a few fundamental problems with this. Firstly, my main point is that there is a clear route under Article 190, and I have not seen any authorities relied on. I've certainly not been able to find any where somebody can rely on Article 185 to 187 on the basis of a representation made by a non-contracting party as an agent. I've not seen any authority which suggests that they can fall within those articles. So I say Article 190.
You're inviting us to construe 190 as a necessary condition for cancellation of a contract where there's been a misrepresentation made by a person other than the contracting party, the necessary condition being that the contracting party knew of the misrepresentation. Why shouldn't we read it as a sufficient condition, leaving intact the general law in relation to agency?
Well, Judge, I would say Article 190 is clear for the reasons set out. And if there was to be any agency findings, firstly, the basis upon those findings was not explored by the judge and not set out in his judgment. And also it's not clear on what basis, on the legal basis that he's reached those conclusions. That most importantly, the respondents don't provide any authorities on these points. They just say, well, of course, it's clear if somebody is acting as an agent of the contracting party, they can fall within Articles 185 to 187. But the terms of each of those articles is sufficiently clear, in my respectful submission, to identify a specific route under Article 190 for a misrepresentation made by a person other than the contracting party. And on the agency points.
Sorry, that would produce, forgive me, I follow what you say, but it would produce some curious outcomes. X says to Y, you go and deal with it all for me. You have my full authority. We're not even dealing with ostensible authority. We're dealing with apparent or actual authority. And Y is squarely within the authority. Y then, fraudulently, with all the mental elements, misleads the other party to the contract. Why shouldn't X bear the risk of that? Which suggests 185, doesn't it?
It does, but what is also fundamental in this case is that there is no finding, and this goes back to your earlier point, Your Excellency. There's been no finding of the judge on intention, on whose intention, and at what point. So, if that assists, Your Excellency, I say that explains that in this case, we cannot get home, or the respondents cannot get home on the point they assert, because there just is that knowledge.
Yes. Thank you.
And on the agency point, it's important to say this because it has been suggested a lot in the respondents' skeleton arguments, but it was accepted at trial that the law on agency was trite law. Well, it's quite clear it's not trite law for as considering the position in this appeal today. And it was wrong to suggest in the skeletons that it was trite law at trial because, in fact, the skeleton argument of the claimant, it set out the position in relation to apparent authority at page 1192. And quite clearly from paragraph 81, it's not suggested that it's as clear cut as the respondents suggest. It sets out that UAE law might recognise ostensible authority when the following conditions are satisfied: the agent acts in the name of the principal, the third party is dealing with the agent in good faith, and the principal acts in a manner that indicates that he has granted his authority to the agent. So the court was clearly addressed on these points by the claimant, and further Dr. Mahmood Hussain provided some assistance to the court at page 1522 of the transcript. But what is fundamentally missing from the judgment is any analysis of how, with respect, the judge has been able to get from point A to point B with Mr. Darzi being clothed with the authority of the claimant. It's just not been explained. It's not been set out on what legal basis that has been found. And that is a fundamental failure in my respectful submission. And my primary submission is that there is a clear route under Article 190. And there are no authorities which suggest that actually findings can be made based on Articles 185 to 187, particularly in a circumstance where there's been no finding on intention or knowledge of the claimant himself. Your Excellencies, that concludes my submissions on ground 4, unless there's anything
further.
Sorry,
just on ground 4, if we're against you, and if we found that 185 was the pathway for, well, let me ask another question. Under 190, do you say it is necessary for the contracting party to know both that the representation has been made and that it is false? Or is it sufficient that they know only that the representation has been made?
Well, Article 190 only says that they had to know that the misrepresentation was made. That is the extent to which it goes.
Right, so then, in this case, if Mr. Almheiri had known that Mr. Darzi was saying that Mr. Humaid was going to sign, then he's liable. If Mr. Darzi was in fact intending to mislead, is that right?
Judge, sorry, the internet cut out in that very important question. Can I trouble you to repeat it?
If Mr. Almheiri knew that Mr. Darzi had told Mr. Cameron that Mr. Humaid was going to sign the guarantee, that would be enough, even if... Yeah. So, in other words, he doesn't need to know that Mr. Darzi had the intent to mislead or have the intent to mislead himself.
Well, it's the Article 190 refers specifically to the misrepresentation. So there would have to be the misrepresentation, and it is assumed from the wording.
So it's the misrepresentation, not the representation. So in other words, he has to know of both the representation and of the intent to mislead.
Yes. And in this case, there was no finding in relation to any of those points.
Well, doesn't that suggest that the judge wasn't actually relying on Article 190?
Well, with respect to Your Excellency, it would have been prudent for the judge to set out clearly on what basis his findings were being made, and that wasn't done. He simply, over the page in the judgment, says, I cancel the contract on the basis of Articles 185 to 187, so he doesn't even specify in that respect upon which article is being relied specifically to cancel the contract. He just refers to them collectively under 185 to 187. So I think that would have been helpful to have been set out in full detail exactly upon what basis the judge was making his findings. So we have a lack of knowledge, we have a lack of any assessment of an agency argument that was put forward, and we have a lack of, well, which article are we relying on? Is it 185? Is it 186? Is it 187?
Well, they're all points you make, regardless of whether 190 is sufficient or necessary.
Yes. Okay. Your Excellency, round 5. So this is the entire agreement clause, which is at clause 17 of the agreement.
Ms. Muller, can I put something to you?
Yes.
If my colleagues will forgive me, but I'm speaking for my own part. Doesn't ground 5 stand or fall with grounds 1, 3, and 4? If there was a fraudulent misrepresentation, can it be said that the entire agreement clause survives? Because it may well be that it doesn't if there's fraud.
Yes.
If that's right, then the outcome on 1, 3, and 4 really determines, for this case, interesting though the entire agreement point is, but 1, 3, and 4 will determine the outcome.
It will, and there is some case law which the respondents rely upon, where it does suggest in serious circumstances where there has been a fraud, that may vitiate consent for the purpose of an entire agreement clause. But in a case where we have no finding of that, in my respectful submission, that just simply can't succeed. So I won't address Your Excellencies on ground 5 now. Shall I then proceed to deal with ground 2, or would you like to hear from Mr. Suleiman on ground 6?
No. Whichever is convenient to you.
I'm grateful. Ground 2. So this again, I've said this a couple of times this morning. In my respectful submission, is a straightforward point, and that is that the judge failed to make any finding as to when the respondent first became aware of the falsity of the representations, and failed to consider at all Article 192 concerning affirmation.
Well, how do you deal with paragraph 48 of the judge's reasons, which frankly I think I got wrong in the application for permission to appeal? Why isn't that a finding that Mr. Cameron first became aware of the falsity of the representations in November 2017?
Judge, I'll need to find that. But the point is, there was evidence, and it was explored in cross-examination, that there was the security check that was sent by
that was years before November 2017.
It was January 2016. Yes.
Yes. So if the judge has found, and I think he has in paragraph 48, which you should look at, that it wasn't until then, November 2017, that Mr. Cameron became aware of the falsity of the representations, then there were no acts of affirmation after that time, were there?
And we're talking about before, acts of affirmation before. So, but he certainly was aware. So from the transcript and the cross-examination, he was certainly aware when providing the security check that the shares had not been transferred to him.
But he said that's because it was always the intention that they were going to be transferred after the transaction was consummated. So in other words, the security check had to be provided, that the loan from QNB, the loan funds had to be acquired from QNB. That was something that would happen after. So that wouldn't have, if there was no intent to transfer the shares, his knowledge, the fact that he knew the shares hadn't been transferred then would not falsify the representation.
Well, and the transcript on this point was at page 440, just for the court's record.
Yes, thank you.
But the point is that he still provided that security check, and nowhere within the judgment is Article 192 specifically considered by the court. Now,
but that might be because the judge found that Mr. Cameron did not know of the falsity of the representations until well after any possible acts of affirmation, and there was therefore no need for him to refer to it.
Well, it was.
But I think you need to deal. I think you need to find paragraph 48 and deal with it, because it seems to me to be a complete answer to this ground.
Yeah, let me just bring that up. Yeah, so paragraph 48 says Mr. Cameron only learned the truth in about November 2017. By this time, he had, of course, signed and returned the indemnity agreement. It is on this basis that Mr. Cameron now resists enforcement of the indemnity agreement.
Right. Well, are there any acts of affirmation that you rely upon after November 2017?
No, and it was made
that's the end of the ground then, isn't it? How does the ground survive that?
And Your Excellency also made it clear when given permission that we couldn't go beyond that long. We could only explore what was put at trial, which was in relation to the security check, and that is the extent of my submissions on that ground. What I will say is that there's still been no consideration by the judge of Article 192 in my respectful submission. Thank you.
Yes. Thank you. Mr. Solomon, ground 6.
Thank you. Yes. And before I turn to ground 6, if I may just deal with one point on ostensible authority under Article 185.
Sorry, are we dealing with ostensible authority or actual authority here?
Well, this also wasn't clear.
If it matters.
Yes. Well, this is perhaps what I was proposing to do was deal with what test was in fact put to his lordship at first instance, and what was said to be the test, because I don't think there was too much disagreement on what is said to be the test applicable. And this is at page 1511, please. And it's Mr. De Wolf, counsel for the respondent, at page 97 within the small pages. And he sets out there are 2 elements to the test, which begins with the sentence that says, we have the third party, Mr. Cameron, believing in good faith that the agent, Mr. Darcy, is authorized by the principal. So just pausing there needs to be a good faith belief by Mr. Cameron that Mr. Darcy is an agent of Mr. Almheiri. We say there's no such finding. And then the second part of that, which is that Mr. Mehery, and then it's emphasized that there needs to be indication that the Mr. Mehery has granted authority to the agent, to Mr. Darcy. And again, no such finding that there had been a grant of authority. What his lordship does in paragraph 56 of the judgment is say that it's from a position of speaking. Mr. Darcy is speaking on behalf of the claimant, that is Mr. Almheiri. And so the test that's been applied here isn't the one that even the respondent had set out, the 2-limb test, the good faith belief, and the grant of authority to the agent. And as Muller said, in fact, in paragraph 16 of the judgment, his lordship recognized this is at page 180, please. Forgive me, page 182. His lordship makes this, we say, a very important finding. He says, over the course of the next 2 or 3 years, led by the claimant GSS and Odyssey, negotiate with the HSBC on restructuring the HSBC loans. The negotiations were carried out on behalf of the claimant, GSS and Odyssey, and the various UBOs by 2 financiers / accountants, Mr. Darcy and Mr. Nedjar, and to a lesser extent, Mr. Darcy's younger brother. And so having made that finding in paragraph 16, it was then incumbent upon his lordship to make a finding that Mr. Almheiri had authorized Mr. Darcy to act as his agent, which was, as I said, the test that the respondent set out. And it was incumbent upon his lordship to make a finding that Mr. Cameron had in good faith believed that Mr. Darcy was acting as his agent, which sits very uneasily with the finding in paragraph 16.
Well,
if I may then turn to ground 6, and I'm going to be very brief with ground 6, for perhaps reasons that might be obvious. The ground 6 really, I think, suggests that too much weight was given to the hearsay evidence. And the reason I'm going to be very brief is that it's not, there are certain words used in the judgment which suggest that perhaps more weight was given than perhaps should have been given. But it's a point that I think is perhaps somewhat, it's difficult to pursue. I think it's difficult to suggest how much weight his lordship in fact granted. What he says,
you could drop the point.
I could drop the point, and perhaps I won't say any more than that. It's there as a ground, and if Your Excellencies wish to consider it, it's in the skeleton argument. I don't think I need to say any more than what's in the skeleton argument.
Yes. All right.
Thank you. And I'll return to Ms. Muller, who's on mute.
Yes. Thank you, Ms. Muller. Anything more?
Yes, I'm grateful. I just want to come back just because I forgot to say something on ground 2, which is also important. I know this is also not one of the favoured grounds, but let me just add something else. So it wasn't just that Mr. Cameron was aware that the shares hadn't been transferred. He was also aware that the equipment leases were not yet in place. So he had that knowledge at the time that the security check was sent. And so I say those two aspects were there, and that ought to have been considered by the judge in terms of Article 192. I just make that point just so I can't be criticised for not making it. I'm grateful. Thank you.
Thank you.
Your Excellencies, we do have Dr. Mahmood Hussain, who can deal with, he's obviously counsel in the matter as well. He's obviously a UAE expert. So if Your Excellencies would like any clarification, or if you feel that Mr. Suleiman and I have not addressed any of the articles in the way that perhaps Dr. Mahmood can do, and then let's please hear from him if you think that would be helpful.
Thank you. But before I invite my colleagues to ask any questions of Dr. Hussain, I just got a question for either you or Mr. Suleiman in relation to paragraph 56 of the judgment, which is where I think the judge does set out his reasons for concluding that statements made by Mr. Darzi bind Mr. Almheiri. And what he says there, and it's at page 198 of the bundle, what he says there is that he is in no doubt that he can be held to the false representation, even though he didn't know it was being made. He says he instructed Mr. Darzi in matters relating to the restructuring of the loan agreements. As far as Mr. Cameron and Mr. Al-Araj were concerned, what Mr. Darzi told them about the proposed arrangements would have represented the claimant's own understanding of the position. Put another way, the claimant put Mr. Darzi in a position of speaking for him in relation to the restructuring of the loan agreements. Now, why aren't they sufficient findings of authority?
I'll start off because Mr. Suleiman may have something to add after I've spoken, but I would start off by saying that those findings also were not consistent with the evidence that was heard at trial, because as Your Excellency pointed out earlier, at page 1342.
That's a different ground of appeal.
Yeah.
You started your submissions by saying there is no challenge to any finding of fact.
Yeah.
So I don't know that we can go there. But why isn't this a sufficient basis for a finding of authority?
Well, he doesn't set out upon what type of authority are we referring to? What UAE analysis of authority are we referring to? Ostensible authority? Is he referring to those principles there? And he doesn't set out. You will recall that I took the court to the claimant's skeleton at trial earlier, where a test of 3 points was set out in relation to authority. He doesn't deal with that, and he doesn't address how, therefore, in conclusion, he feels that he can then have the finding that he makes that the claimant put Mr. Darzi in a position of speaking for him. Mr. Suleiman, is there anything that you want to add on to that?
The point, I think the short point is that the two-limb test, which the parties, in fact, I think somewhat agreed on, which is the first that Mr. Cameron, there had to be a good faith belief. There isn't any finding that there was a good faith belief. And the second, and perhaps more important limb, which is that there was no finding that Mr. Almheiri had actually instructed Mr. Darzi in relation to these 3 representations to act as his agent. Because the finding that it says he was instructed in relation to the restructuring of the loan agreements. That sentence in paragraph 56 that begins with, he instructed Mr. Darzi in relation to restructuring the loan agreements. That's That is correct, and insofar as it ties in with paragraph 16 of the judgment. Mr. Darzi was, in fact, instructed by both the appellant and various other parties in relation to the restructuring of the loan agreements. But it doesn't address the authority that the claimant may have granted to Mr. Darzi to make representations on his behalf in relation to those three statements that are said to have been made.
Yes, right, thank you. Well, now, I'll just ask my colleagues if they have any questions of Dr. Mohammed Hussain.
No, thank you. Not currently in my case.
Justice French?
Yeah, same for me, thank you.
My
Thank
lord,
you.
if you would like, I can tackle a little bit the entire clause agreements in the agreement. If you like, it's enough, then there is no anything for me to add.
Well, I don't think we need to go there, Dr. Hussain, because I think the view we're currently forming is that will stand or fall with the other grounds 1, 3, and 4.
Thank you very much, my lord.
Thank you. Right now, we've been going for an hour and a quarter. We're under time, which is good. This might be a time for a short break, and perhaps the judges we might go back to the link that we were on earlier and have a quick chat. So why don't we adjourn then for 15 minutes, and we'll return after that. So we'll return at well, let's return on the back at 13 minutes. We'll return on the half hour wherever you are. Okay, I think we're all reassembled. Mr. De Wolf, over to you. I can tell you, however, that the court doesn't need to hear from you in relation to grounds 2, 5, and 6. So in other words, we only need to hear from you in relation to grounds 1, 3, and 4, which are the grounds concerning deceit.
Okay, just give me 1 second. Okay, so you don't need to hear from me on affirmation.
No.
That's ground 2. Ground 3.
No. Yes, grounds 1, 3, and 4. We'd like to hear you.
Okay.
At grounds 2, 5, and 6, which are affirmation, the entire agreement clause, and the hearsay evidence. We don't need to hear you.
Okay. Very good. Before I get started, can I just check that the court has the commentary to Article 185, which was sent by my colleague, I think, this morning? Yes.
Yes.
And then 2 tables which were provided to Justice Glennie shortly before the closing submissions at trial.
Yes.
Okay,
what are we to make of those tables? What's their purpose?
That was the well, that came as a result of a request that was made by the judge at trial for the parties to pull together the sort of evidential table of transcript references and document references in terms of evidencing the deceit in this case. Yes. The other purpose is to evidence the ostensible authority. So table 2B, so that's just page 2 of that table, speaks to or looks at the circumstances with reference to the evidence in which Mehdi Dazi was acting for Khaled. And then if we scroll down and we go to table 3.
Well, just pausing there, Mr. De Wolf, I could understand the utility of that table if I was the trial judge, or if I was an appellate judge hearing an appeal against a finding of fact made by the trial judge, but I'm neither of those things. I'm an appellate judge hearing an appeal on the basis that the finding wasn't made, not that it was made wrongly. So what use could I make of that table?
The point of having the tables at this stage is to show that when the judge was considering ostensible authority, and we looked at the transcript before where he was, where the test was explained to him, this is what we had in mind. This is what the evidence that he was working with in terms of the conclusions that he reached. So the simple point to make is there was a sound basis for the conclusions that were made at 56 of the judgment.
I see. All right.
That's all it is.
All right. Thank you.
I don't intend to go through the table in any great detail.
Good.
So it was said at the outset, Your Honour, to you that this is not an appeal on the facts, but the facts in this case do bear directly on Justice Glennie's findings. I think it's relevant, therefore, that we look at.
Well, when you say the facts, you mean the evidence?
Yes, in terms of the history of how these proceedings came about and the circumstances in which these representations were made to Mr. Cameron. So it's important to understand the story that sits behind that. It's not sort of representations that were made off the cuff. They were made in the context of a complex transaction, a restructuring of a loan. And before that restructuring took place, there was another loan in place. So it's important to understand what happened in that sort of storyline that leads up to these representations being made. So you have the benefit of the chronology at Schedule 1 of my skeleton. That's page 2610.
Yes.
I don't want to walk through that in great detail, but just sort of to pick out some key aspects from that. And you obviously have the benefit of that. And that chronology has cross-references to the judgment, so fact findings that were made by the learned judge, and where relevant, document references.
Sorry, which page is that again?
2610.
Thank you.
So the story starts in 2007, and that's when a group of people, a total of 9 people, come together and they start a new business. And those same group of 9 people, they eventually come to be the UBOs of those 2 businesses. The appellant and the respondent are 2 of those people, but there's also Ezeldin El-Araj, who was formerly the first defendant in these proceedings, who was another. But there are also 6 others. Now, those 6 people included, I'll call them VIPs. One was a Qatari minister, at the time Qatar's then Minister of Finance, the chairman of Qatar Sovereign Wealth Fund, and the chairman of QNB Bank. And the relevance of that bank will become relevant later on in the story. And we also have a member of Qatar's ruling family, Sheikh Al Thani. Now, to start a business, of course, you need capital. So what these people did is they went to a bank, HSBC, and HSBC agreed to give them $100 million. But obviously, a bank is just not going to give you the money like that, so it needed security. And I got quite a bit of security, HSBC. It was a mortgage over land in Javsa, it was a mortgage over plant and machinery, and was assignment of contract proceeds. And in total, that security came up to about $109 million. And again, Your Honor, you have the references to the relevant provisions in the judgment in that table, but that figure wasn't disputed at trial. So it's common ground that the security that HSBC held in respect of the loan was 109 million. And on top of that, the HSBC also had personal guarantees from each of the 9 UBOs, including the Qatari minister and including the member of the Qatari family. So what happened then is that the 2 companies that were set up by these 9 people weren't able to repay their loans, and HSBC had to decide what to do about it. Well, they could do one of 2 things. They could effectively take a hard line and force the security, or they could go soft and accept to take a discount or a haircut on what they were owed. Now, HSBC didn't want to take a hard line, and they didn't want to take a hard line for a simple reason. They didn't want to be involved in a public spat with 2 Qatari VIPs, let alone a Qatari government minister. Now, so they didn't really do much about it. It wasn't a concern of Mr. Cameron that HSBC was going to come after him, because if they were going to come after him, 1, he knew that HSBC had the benefit of the security, 109 million, and he knew that he had the benefit of these 2 VIPs that had also given guarantees.
Mr. DeWolf, this is an interesting story, but I'm just not sure how it's helping me, because we can only act upon the judge's findings of fact. And unless there is a finding of fact, I can't see how your narrative is going to have any influence upon the outcome of this appeal.
It explains how the representations came about.
But only if we accept everything that you say. And I can't accept everything that you say unless it's a fact found by the judge.
It is.
Or it's common ground.
It is, which is why you have the benefit of the chronology. So what I'm saying now is reflected in the chronology, with reference to relevant paragraphs of the judgment.
Well, it would. I think it would be more useful to me if you identified what the judge, if you took us to what the judge said about it, rather than your, you're putting words to what the judge said, I think, in this narrative, and I'm not finding it terribly helpful, to be frank.
Well, you have the benefit of the chronology. We can turn to
we've all read the judgment. You can take that for sure. So we know the background.
Yes.
I'm just wondering what's the purpose of this?
To set the scene for the representations that were made and the context in which they were made. But I'm happy to move on. I thought it would be helpful. This is obviously an appeal to set out the case that was before the judge, the case that he was dealing with, and the context in which he was dealing with the representations, because he does spend quite a bit of time going through that background. So I wanted to make sure, of course, that you have the benefit.
We've read it all. We understand how it came about. There was a problem with the original lender, and there had to be renegotiation and restructuring. Now, what's more to it than that? I mean, and we've also read what the judge said about the emphasis Mr. Cameron placed upon the importance of the guarantee from Mr. Humaid because of Mr. Humaid's position with the QNB.
Yeah, well, I think the key point is one, that you had 9 people to begin with.
Yeah.
And you're left with 2 people.
Yeah.
So why are you left with those 2 people?
Well, you were left with 3. You were left with 3.
You're left with 3, yes. But effectively, on the appellant's case, he says he obviously has the benefit of the guarantee, so he's not really exposed in that case. But you have what are left with effectively 2 guarantors. Before you had 9. So obviously the question arises, well, why did those 2 stay on? And the simple point there is, well, it's because of what they were told. Why else would they stay on? There's no reason for them.
Well, see, that's the problem. That's not a finding of fact that the judge made. The finding of fact that the judge made was that there were matters that were of significance to Mr. Cameron. Now, Mr. Cameron gave evidence about why he stayed on. He chose, all the others wanted to bolt, including Mr. Almheiri wanted to bolt. Mr. Cameron gave evidence, and I think there's real danger in you putting propositions to us that are not founded in the judgment. Propositions of fact that are not founded in the judgment, because there's no appeals from any of the findings of fact made by the judge.
No, look, I will move on. I think the simple point is these representations were made crucially in the context of this restructuring exercise. You had 9 people to begin with. You're now left with 2. That's a simple point there to make on that. And you're very familiar with the 3 promises that were made in the context of that restructuring. And then which Mr. Cameron says, of course, formed the basis on which, and it's also actually fact-finding made by the judge, that those 3 things formed the basis on which Mr. Cameron ultimately signed the agreement. And we'll come on to, in more detail, what the judge said on that. So I'll deal with that sort of factual background in mind. I'll look at the relevant grounds of appeal that are now left. The first one is this concept of trickery and gross cheat. And the point there was made, well, the judge only dealt with we'll call it the Humaid guarantee, but he didn't deal with the other representations. Well, that point is answered at 56 of the judgment, at page 198 of the bundle, where he says that he used the Humaid guarantee as an example, but that his observations equally apply with respect to the 2 other representations that were made.
But that's the problem, isn't it? It's a finding made at such a level of generality that it doesn't provide, it doesn't establish findings of fact that needed to be made in order to conclude that a representation, for example, to the effect that shares would be transferred in the companies to the guarantors was fraudulent. In other words, who is it said that there was an intention to transfer the shares? And if so, whose intention was it? When was that intention false? And if so, when did it become false? They're all the questions that are elided in a simple observation of the kind found in paragraph 56.
I think I'll come on to this, but we have to move on from this notion of a misrepresentation to a deception. Because under UAE law, there is no notion of misrepresentation or a different hierarchy of misrepresentations. There's no innocent misrepresentation, negligent misrepresentation. There's only a single concept of deceit. So we have to start with, that's a starting point. It's only deceit. And we know that from Article 185. If we go to page 1830 of the bundle, that explains in very simple terms what misrepresentation is at a high level. Misrepresentation is effectively deception, but it doesn't actually tell us what deception is. It tells us that misrepresentation is deception, but it doesn't tell us what deceit is or what deception is. So that of course begs that question, and to answer that question, we have to go to the commentary to 285, because actually the Civil Code deals with deception on two occasions. It deals with it in the context of contract formation, which is 185, and it deals with it in the context of tort. But the concept is the same. We're still looking at deception. There's only one concept of deception. So if we go to page 2672 of the bundle, because that actually explains in quite some detail what deception actually is. So that's the official commentary to the UAE Civil Code.
When you say official, what do you mean by that?
It's the James Whelan commentary that is often cited to courts in this region in terms of helping them to understand what a provision means.
But it doesn't have official status.
It has sort of status in the sense that Almheiri does. It is accepted legal commentary, and it's right. It is an authority, recognized as an authority.
All right.
So the DIFC courts have themselves used it in the Larmag case. When they were looking at deception, they looked at the commentary and they made observations about deception with reference to the commentary that's given here. Right. So it's not something that's new to the DIFC courts. It has been used by the DIFC courts, and it's also used by the ADGM courts.
I don't know. What are you taking us to?
Well, the very simple description of deception,
yes.
Which is, I think it's the second big paragraph on the right-hand side of that document. So what is deception? It's making somebody accept what is no good by lying and misleading means, and inducing them to proceed in circumstances.
So which page are you reading from?
2672.
Yes.
And then on the right-hand side of that document.
Yes.
Just below historical reference.
Oh, yes. Okay. Yes, I've got it.
Yeah, I think that's quite a helpful description of deception. And it says, making somebody accept what is no good by lying and misleading means, inducing him to proceed in a circumstance where if he had known the truth, he would not have proceeded. I think that's quite a useful description of what deception actually is in UAE law. So it's not we shouldn't get confused with this concept of misrepresentation.
Well, except that this is in the context of Article 285. We were taken to cases dealing with Articles 185 and 187. They deal with misrepresentation, fraudulent misrepresentation, don't they?
Well, they deal with deception because 185 explains misrepresentation is deception, but it doesn't actually explain what deception is. And to understand what deception is, the commentary to 185 doesn't help us, but the commentary to 285 does. And it's the same notion of deception. So if we look at 285, it says if a person deceives another. So we're dealing with the same concept of deception. We're not dealing with two different concepts of deception. There is only one concept of deception. And this is a helpful explanation of what that concept actually is, because Article 185 tells you how you can deceive someone. So by lying to them, or by acting in a way where you intend to mislead, but it doesn't actually explain what deception is as a concept. That's why I think it's so important to have this commentary to understand what that concept of deception actually is. The other good thing about this commentary then goes on below to explain the means of deception. And that's by word, that's verbal deceit, by lying, or by deed, so physical deceit, where you do something with the intention to mislead. And we'll come to look at case law in a moment of what that actually means. And then it goes on to give some examples of what deception is in certain circumstances. So at the bottom of that page gives the example of sort of persuading someone to go down a road by making the other person think it's safe when in fact it's not safe. And that's sort of exactly what's happened here. Mr. Cameron was led to believe that he was signing something, that it would be supported by a number of other things, that Almheiri would also give a guarantee, but actually the reality was very different. So he was misled as to what was actually...
Well, we know that Mr. Almheiri did not sign the guarantee, but that doesn't establish that the representation that Mr. Cameron was misled at the time he was told that Mr. Almheiri was going to sign a guarantee, does it? Unless the person who made the statement knew that Almheiri was not going to sign a guarantee, there's no misleading.
That's exactly right. So if we go to page 1116, that answers the question that you had on the timing of what Mr. Dazi or Mr. Almheiri knew at the time.
$1166.
So 1116. So 1116.
Oh, sorry.
Yeah. And he helpfully underlines that timing point for us as well. It's paragraph 73B of Mr. Almheiri's witness statement. And he explains that, well, D2 is Mr. Cameron. Mr. Cameron knew from Mr. Mehdi Dazi that Mr. Almheiri would not be providing indemnity before he entered the indemnity. Mr. Almheiri informed me that his role was simply to facilitate the loan. So quite clear
what is this document?
This is the witness statement from Mr. Almheiri, so the appellant. I believe it is his fifth witness statement. So he tells us when he knew, and that he told Mr. Dazi to tell Mr. Cameron before he signed the indemnity agreement. So I hope that answers your timing question of when he knew.
Yes. Right.
If I may, I would like to continue with the concept of deception. So we go back to 2672. And so just on the knowledge point, I should say obviously that extends to Almheiri, the appellant, and extends to Dazi as well, because Almheiri tells us that he told Dazi about it. So that knowledge aspect of awareness and knowledge applies to them both. So 2672, the commentary to 285, we looked at what the concept of deception is. We looked at the means of deception. So by saying something or by doing something. And it seems that the appellant takes issue with this last point, the means of deception, that it has to be, or there has to be some sort of separate and independent finding of trickery, and that absent this finding of trickery, there is in fact no deception at all. But that's not how the UAE courts have approached it. And it's actually this reference to trickery is used interchangeably with fraudulent means, deceptive means, misleading means, or even simply persuasion. And that simply derives from a translation issue that arises from the Arabic. And we can see that from the commentary to 285 that we looked at here. So making somebody accept what is no good by lying and misleading means. So lying and misleading means in this case would be that concept of trickery. It's just framed slightly differently. If we go to the commentary to Article 185 itself, which we provided to the court this morning, on the right-hand side of that document, where it looks at Article 185, it says, when one of the contracting parties deceives the other by means of fraud, then it has a little reference to also trickery. So we see there that trickery is fraud. And we saw in the commentary to 285 that trickery or fraud can also mean lying and misleading means. The point I'm making here is that when we're talking about trickery or fraud or misleading means, what we're really talking about is the concept of deception. There's no independent requirement that sits outside of that to make a finding of trickery.
Okay, but just pausing there.
Yes.
Do you accept, therefore, with trickery being embedded in deception, that that requires an intention and knowledge?
Yeah, I was going to come on to that point. So if we deal with that now, if we take one of the many cases as an example,
Well, just before we go to cases, do you accept that?
I accept that, and this is what the commentary explains as well, is that when you deceive someone, you hope to sort of get something out of it. There's an illegitimate purpose. So
hang on a minute. Hang on. I understand, were there to be a concept of innocent misrepresentation, that somebody could be misled without a fraudulent intention on the part of the misrepresentor. But here, it looks like trickery or fraud is, as you say, embedded in Article 185.
Yes.
If that's right, it suggests to me at least that the representor must have an intention to deceive. And all I'm trying to ascertain from you at the moment is, do you accept that?
I accept that there is no concept of sort of this innocent deception. Deception has inherently within that concept something that is sort of deliberate. And that is exactly the observation, and I'll come back to that, exactly the observation Justice Glennie made at trial. And it's the same observation that Dr. Hussein made at trial. When he talked about 185 and this concept of trickery, we'll come back to the transcript, and he explained that it's sort of implicit that you have this dishonest intent within that. Okay. So yes, that is the right way of putting it. It's the way it was put at trial, and it's the way that Justice Glennie interpreted it. We say that's right. And at trial, the appellants said that was the right approach to take as well. And I'll give you the relevant references in a moment, so you can see what was sort of playing in the mind of the judge when he made the findings that he did, which are reflected in the judgment.
Well, where did he find dishonesty? And whose dishonesty was it?
Well, at all times, all the representations were made by Mr. Mehdi Dazi on behalf of Mr. Almheiri. So the
where's the finding that Mr. Dazi was dishonest and intended to mislead Mr. Cameron and made the representation for that purpose?
So we go to 43, and that explains the timing of when Mr. Cameron was told what. So it says
page number.
Just 1 second, Your Honor.
Page 195, if it assists the court.
Thank you.
Yeah, so 194 at the bottom of that page. That's paragraph 43.
Yes.
Where Justice Glennie explains what Mr. Cameron was told and when. The when is before he signed it, and the what sits just below that. Then he goes on in 48 to explain that the representations that were made by Mr. Dazi were not true.
Well, what does he mean by that? The evidence is that none of the events came to pass.
So he yeah, sorry.
What that's not a finding that whosever intention was relevant for the three representations did not hold the intention, is it?
Well, it's so we talk about deceit, we talk about dishonesty. Not so much intention. Intention comes into play when you mislead by an act. So all the cases, Dubai Court of Cassation cases, distinguish between verbal deceit, which is lying when you lie, and between physical deceit. That's when there's an act which is intended to mislead.
All right.
So
Well, you'll need to make that proposition good by taking us to cases in due course, but let's deal with that later.
So I'll deal with that point after just in terms of going through.
Sorry to interrupt. There are two intentions in play here, aren't there? There's the intention to mislead, which is, if you like, the fraudulent intention. There's the implication from a promissory statement that somebody has a present intention to honour the promise. There are two different intentions, and it's the latter that I think His Honour is addressing in that rolled up way in 43, right?
Yes. So he was saying that somebody had the intention that these things would come to pass. And now when in 48 he says none of them were true, it's not clear that he's relying upon anything other than the fact that they didn't happen.
If read in isolation like that, yes. If read in context of the judgment with other provisions, which I will take you to, then no. That'll be my submission on that. And we have to understand that when we're looking at what the judge was looking at, he was looking at it from the perspective of deception. So the commentary to 285, making someone accept something which is no good by lying, to induce him to proceed in circumstances where if he had known the truth, he would not have proceeded. So what Glennie explains about all that is it starts with 43, which says before signing, Mr. Cameron was told all these things by Mr. Dazi, that all these things would happen. And just below that, he explains that all of these things, although expressed as in terms of matters that would happen, they could without difficulty be rephrased so as to amount to representations of fact, that it was a then intention. So if we look at 48, we can read that in two ways. If we read it in the sense that it's a representation as to what would happen, that is false, it didn't happen. If we read it in the way that Glennie explained,
that's a prediction. You can't just say that because I say something is going to happen, it doesn't happen, that I was being fraudulent. That's an impossible proposition.
No, and that's why it's important to understand how Glennie was approaching this. So in the permission to appeal application where he refused permission, he explained that what he was looking for when he's looking at the evidence was not just whether something was true or false, so the falsity itself, but also whether the lie was deliberate and material. And he says that in paragraph 18 of
yes, but he doesn't go on and say who made what lie and why it was deliberate. So in other words, he expresses a conclusion, but he doesn't actually augment the gaps that the appellants rely upon, because he doesn't say whose intention was it that these things would come to pass, and what is the evidence that they did not hold that intention. It seems that all he's done is say, well, they said these things were going to happen and they didn't, therefore there's been fraud, and that just can't be right.
No, not quite. So when he was looking at deception in 185, as described in the commentary to 285, he was looking for exactly what a judge should be looking for, which is what the commentary explains, which is that you say something, in this case, to make someone believe something that is something, but it really is something else. And that's exactly what the judge found here.
Mr. Wolf, I don't understand what you're saying. Are you saying that Article 185 is satisfied by somebody saying something will happen in the future that doesn't happen, that's enough?
You need to deceive to get something, so to procure someone's consent.
Well,
and that is
can you answer my question? My question is, are you submitting that under Article 185, the requirements are met by making a representation that something would happen in the future, and that the article is satisfied merely if that thing does not happen? Is that your submission?
No, you need to know.
Well, can you clarify me what your submission is, because I'm having trouble grasping it.
Yes, so when you say that something is going to happen, you need to know that something isn't going to happen. You need to know the truth. And we looked at the timing finding, and we saw from Mr. Almheiri's evidence that he knew the truth before Mr. Cameron signed. And he also told Mr. Dazi about it. So we know from the evidence, Mr. Almheiri's own admission, that he knew the truth. But that wasn't communicated to
Mr.
Mr.
Niels,
Cameron.
one can look at look at the statement in 48, which is the crunch point.
Yes.
None of those representations were true. Now the question is, what are those representations which were not true? What His Excellency has done is to go to A, B, and point C, being a reference back to 43.
Yes.
And it seems that the representations that were not true were A, he would receive shares, etc. B, Mr. Almheiri would be signing, and C, that the HSBC loans would be paid. Now the question is, what falsifies those representations? It must be the fact that they didn't happen. When he says none of those representations were true, isn't it? Isn't that how the reasoning appears to go on the face of it?
If we ignore the bracketed bit that sits below 43 in terms of purely talking about the falsity of what is there, that it didn't happen, yes, it didn't happen. That's a matter of fact. But what he was saying and what he was considering here, he was considering it in the context of deception. And the way that he put it, the way that it was explained at trial, in terms of looking for deliberate and material deception. That's what he was looking at. So effectively, was Mr. Cameron lied to? That's what the question he was engaging with. And if we go to 56 of the judgment, it talks about a false representation that's made by Mr. Dazi. And 61 of the judgment, almost at the bottom of that paragraph, he explains that Mr. Cameron, that fact that Mr. Cameron was told about the circumstances in which he was being asked to sign the indemnity. So those are the 3 points that we looked at, A, B, C. And he explains that he was misled as to those circumstances. And that's exactly what deception is you mislead someone into making them do something, in this case, procure consent, in circumstances where they otherwise wouldn't have done so.
Right. Well, where's the finding that there was no intention to transfer shares to the guarantors?
Well, I think as a matter...
Where's the finding that there was no intention to enter into equipment leases that would provide the money to pay the bank loan?
Well, I think that the way the judge dealt with it is he used the Humaid guarantee as an example and then made the observation at paragraph 58 that those same observations also apply to the other two representations. That's my reading of his judgment.
Well, but is that a satisfactory way of entering judgment against a party for millions of dollars? Saying it's the same applies, mutatis mutandis. I mean, surely he would have to make a finding, well, there is some evidence that by this time there was no intention to transfer shares to the guarantors, or there was no intention to enter into the equipment loan. You can't just say, well, because there was no intention for Humaid to sign a guarantee, it follows that there was no intention to enter into the shares, to give the shares or enter into the equipment leases, can you?
I can just go off on what the judgment says and what
right.
His Honour sort of explained in the sort of refusal to give permission to appeal. It just appears to me that he cited the 3 representations. He explained that they were false, and he explained in his subsequent refusal to give permission to appeal that these representations could equally be treated as representations of the then intention, which was false and it was untrue at the time, so it was falsely held.
But there are no, in the refusal of permission to appeal, there are no findings of fact to sustain that proposition. There's simply a conclusion.
Well, to make that finding, the judge would have had to consider the evidence. So,
but he hasn't made findings. Judges have to make findings of fact. They can't just say, I've considered the evidence and this is my conclusion. Surely they have to make findings of fact. And what inferences do we draw as to the findings of fact that he made in relation to the equipment leases or the transfer of shares in the SPVs? It's just
I can only go off what the judgment says.
Well,
So
that's a problem, isn't it?
so far as concerns the equipment leases and the receipt of shares, the judge doesn't deal with that in a great level of detail in the judgment, no. But so far as concerns the Imadi guarantee, it does. It uses that as an example to walk through that, to look at the different elements that have to be met. So first, he says, he explains what Dazi was told before he signed the indemnity agreement. He explains that that was false. In other words, a lie. That's paragraphs 43, 48, 56. He then explains that what Dazi had said, in fact, persuaded Mr. Cameron to sign the indemnity agreement in the first place.
Well, just pausing on what Dazi, there's issues of timing here, aren't there? Because there's no finding as to the time at which Dazi told Cameron that Imadi was going to sign the guarantee. You point to evidence to the effect that at some point in time prior to Imadi signing, Dazi was told by Almheiri that Imadi wouldn't sign. But we don't know whether that was before Dazi made the representations to the effect that he would sign or after. And it may be that if it was after, then the representation wouldn't have been false at the time it was made. It would have been a situation in which there was an omission, a failure to correct a previous representation. But we just don't know what the judge has found in that regard, and you still need to deal at some stage, with the apparent lack of any finding that it was Dazi's intent to mislead Cameron.
Well, the point on intention is it's simply to deceive, and when you deceive, you have to have a dishonest belief in what you're saying. So you're lying about something in order to procure someone to do something. So the example.
Well, there has to, yeah, exactly. There has to be an intention to procure. So in other words, there has to be a finding that Dazi lied to Cameron in order to get him to sign the indemnity agreement. And where is that finding?
Paragraph 55 of the judgment. So 198 of the bundle. He explains that the representations that were made were a material factor in persuading Mr. Cameron to sign.
But that's a reference to the effect which they had upon Cameron. It's not a finding of intent on the part of Dazi.
If we go 1 second, the commentary to 285 talks about deception and cheating in the context of persuasion.
Well, I don't think that's going to help you answer the question that I've asked, and that is, where is the finding that Mr. Dazi told a lie for the purpose of inducing Mr. Cameron to sign the indemnity?
Let me see. So the findings that he did make is there was a lie. That lie he intended therewith to persuade Mr. Cameron.
Well, the finding was there was a false statement. He doesn't make a finding that there was a lie, does he?
Well, he says that in the subsequent refusal to permission order. He explains what he meant by that, paragraph 20 of that. He says at paragraph 43, I was prepared to find that this was a representation that was a then intention. And he explains that is a representation of fact, which was untrue and was known to be untrue. So he does explain that what he was looking for there when he was talking about the intention bit, that intention was not truthfully or dishonestly held at the time that the representation was made. So he does address that question. In terms of persuading...
Sorry, Mr. Dwarf, hang on.
Yes.
So you want to sustain a judgment on fraud, which doesn't make a finding in the judgment, but depends on a commentary in refusing PTA and deals with one of 3 misrepresentations. Is that right?
I wouldn't say quite right. It's a commentary. It's an amplification of the reasoning that was given in the judgment. And I think that can be used to supplement the judgment.
Where's your authority for that?
We have
using it in this one?
Greenwich. Yeah, we have Greenwich and Essex at
Where's that?
page 2123 of the
Hang on,
bundle.
hang on, hang on. And which paragraph, please?
Paragraph 7. It's citing the English
Okay.
and Emery case.
But let's, while Sir Peter's looking at that, let's say you're right, and we go to paragraph 20 of the PTA reasons.
Yes.
All he said was that there was a statement that was known to be untrue. That's a conclusion. Mr. Darcy didn't give evidence. So where is the findings of fact from which he could have concluded that Mr. Darcy knew it to be untrue? Now, you've pointed to evidence in the form of Mr. Almheiri's statement, but the judge didn't make that finding. The judge didn't find Mr. Darcy knew it to be untrue, and even if you've still got the next problem, which is that the purpose of Mr. Darcy making a false statement was to induce Mr. Cameron to sign the indemnity agreement.
Yeah, so
and you can't find that anywhere you can't find that in 55.
So to answer your question, to answer your first question, the judge did say at paragraph 20 that it was a representation of a fact which was untrue and known to be untrue at that time. Yes. It doesn't cite the evidence that the judge was intending to refer to there.
But it's a conclusion.
It's a finding of fact, yes.
Yeah, no, it's a conclusion. Findings of fact are Mr. Darcy knew something at this time. Mr. Darcy made a statement which at that time he knew to be true. Paragraph 20 is really a conclusion to try and justify earlier conclusions. But surely you've got to say, well, the representation was made at this time. Darcy knew by this time that it was false. So either it was false at the time that the representation was made because he found out at this time that it was untrue. You've got to say how Darcy found out before he made the representation, before you can say it was false at the time it was made, and there just aren't any findings of fact in that regard.
To answer your question, how did he find out? Well, the appellant tells us that he told him because the
appellant but he doesn't say when, and he doesn't say whether. It doesn't say whether it was before Mr. Darcy made the representation, Mr. Cameron, or after. And the judge doesn't make any finding on that subject.
He says that it was before Mr. Cameron signed the indemnity. Yes. And what the appellant explains in his evidence is that Mr. Cameron operated on the assumption that Mr. Emadi would be giving a guarantee. Why otherwise would you want to tell Mr. Cameron that he's not going to give one? So
sorry, what just repeat that again. What was the evidence you're relying on?
So if we go back to 1116, just to see what that says in terms of timing.
Yes.
It's clear from 73B that Mr. Cameron operated, before he signed the indemnity, operated on the assumption that Mr. Emadi would be providing a guarantee. Why else would...
So this 73 is Mr. Almheiri's evidence.
Yes, he's explaining here when he found out the fact that Emadi would not be providing a guarantee and the fact that he told Mr. Darcy about it.
Yes, well, all we can get from that is that it was sometime before Mr. Cameron signed the indemnity agreement, but we don't know whether it was before Mr. Darcy told Mr. Cameron that Mr. Emadi was going to sign an indemnity agreement, do we?
Well, the other thing we learned from this...
I'm sorry, do you accept that?
The fact that we don't know whether this, whether it was before Mr. Darcy told Mr. Cameron.
Yes.
Well, the difficulty with that is that this is not one email in terms of the representations that we're looking at. It's a series of representations that were made to Mr. Cameron explains this in his evidence. that a series of representations that were made to Mr. Cameron in the context of the restructuring exercise. That exercise took place from 2012 all the way up to 2015.
Well, the problem I'm having, the more you go into the facts, Mr. de Wolf, the more there appear to be gaps in the judge's evidence, in the judge's findings to me, because none of this is addressed in the judge's findings.
May I, while you're considering how to deal with that rather challenging question, may I add another one? If you're going to place all your reliance on 1116, on the face of it, the claimant acted entirely honestly. Mr. Almheiri told Mr. Darzi to correct any wrongful impression.
Yes.
So you'd be throwing into very sharp relief the Article 185, 190 point about what the claimant needs to know and what his state of mind had to be.
And whether Darzi was acting within the scope of his authority.
Exactly, with respect to the Chief Justice.
The judge actually asked that question at trial, and the answer to that is simply that under UA law, an agent's fraud binds the principal. An authority was cited to him at that point. I will need to dig that out. I don't know the answer.
We'll need to dig that out because, as we've made clear, we're not going to rely on any assertions as to UAE law unless they're documented.
Yes, we will find that for you. It's in one of the many tables that we provided to the judge, because he asked that question, so he was very much alive to this point. So I'm hoping I can answer.
But you still haven't you still haven't taken me to any finding by the judge that Mr. Darzi made the statement that he made, knowing it to be false and for the purpose of inducing Mr. Cameron to sign the indemnity agreement.
My answer to that is a combined reading of 43, where he talks about the misreps, 48, where he explains that these representations were false, or seen from another perspective, where he says that the then intention that this would happen was not true, or dishonestly held. That's 43, 48.
Sorry, then, 48. Just what page you just I've gone to the what page you take me to? What?
Sorry,
it's 198, is it?
It starts at 43 is 194.
43 we've looked at many times.
Yeah. Then we've got
48.
48, which is 195.
Well, that's there's no finding there that Mr. Darzi made a statement for the purpose a statement which he knew to be false for the purpose of inducing Mr. Cameron to sign. Is there?
Then we've got that talks about the falsity or the dishonesty of the intention.
Where's the word dishonesty in 48?
That is dealt with in the PTA order. So the reasons for dismissing the permission to appeal application. But my point there is that the court can take account of what is said there, and there's authority, English Court of Appeal authority, which supports that. That's 43, 48. Then we have 55.
So you write a judgment, leave out the crucial finding, and when, as luck would have it, someone seeks PTA, you lob it in there.
It doesn't. With the greatest respect to the English Court of Appeal, that just doesn't sound right to me.
That's the. I mean, it was one Court of Appeal citing another Court of Appeal decision. So I think it is quite an established principle.
I'm staying out of this one.
Is there any DIFC authority on this point?
I will have to look. I don't know off the top of my head.
Because unless I'm not sure that I would be as I read the cases, and I've read the cases to which you refer, I think they say it's an option that's open to the Court of Appeal. It doesn't. You don't have to do it in every case. And I think the point Sir Peter made was that in a case in which there is an allegation of fraud, it would be an unusual case in which to say the judge can augment findings of fraud that weren't made in the reasons for judgment by whacking them in answer to an application for PTA.
I think the difficulty the judge had, with due respect to Justice Glennie, is that we're dealing with translations, and we're dealing with trickery and deceit and so on and so forth. We are necessarily, there is an element of hyperbole, and he made that point exactly. So,
but let me put this also to you. I think one of the difficulties he had was that you never clearly pleaded your case in relation to fraud. Because as I read your pleading, all that you ever said was representations were made with respect to things that were going to happen in the future and they didn't happen. Therefore, there was fraud. Now, that's just not right. So doesn't the problem stem from the inadequacy of the way in which your case was pleaded?
No, because the way we positioned it was you had a number of misrepresentations, a number of things that were said to Mr. Cameron in the context of a restructuring, and that those things weren't true, and that the intention there was to mislead Mr. Cameron into signing this indemnity. And that's the sort of Mr. Dazi, Mr. Almheiri, they knew that Mr. Cameron would only sign it in circumstances where these things would happen. That formed the basis for Mr. Cameron entering into the indemnity agreement in the first place. That is a finding of fact that the judge makes. So not going back to sort of making new allegations of fact. That's a finding the judge makes where he explains
which finding is that? Sorry, which finding?
The fact that these representations form the basis on which Mr. Cameron entered into the indemnity agreement.
Yes. Well, yes. Now, but that doesn't say that they were made. That's not a finding that they were made by Mr. Dazi for that, knowing them to be false and for that purpose, is it?
For that purpose, to answer that question, we're looking at 55.
Well, yes. Let's look at that.
And that talks about Mr. Dazi making a representation, which formed the basis for Mr. Cameron's understanding about what happened. And there's no doubt to my mind that that representation, that the new arrangements were to include indemnity for Mr. Almheiri.
Well, that's a finding of the effect which the representation had upon Mr. Cameron. It's not a finding of Mr. Dazi's intent, is it?
Not explicitly in those terms, no.
Now, in just following up on that point, if you go down to 58, you see how His Excellency is characterizing the representations. He says, I have focused on the representation as to what was intended regarding the giving of an indemnity by Mr. Almheiri, but the same applies to so he seems to have transmuted the representations, following on from what he said in brackets in 43, into representations about somebody's intention. But we don't know whether it was Mr. Almheiri's intention. Perhaps it was. I don't know.
I think that goes back to the restructuring exercise, which Justice Glennie explains was initiated by Mr. Almheiri, and he was engaged throughout, and it was carried out through Mr. Dazi. So that goes back to the point about who were these promises made by and to whom. That I think is addressed in the judgment in 43, 48.
But who was the repository of the represented intention?
Well, Mr. Dazi was conveying the message. He was the one dealing with the restructuring. So it was his intention, whether that was honestly, dishonestly held, which is why paragraph 20 of the refusal to grant leave deals with that in that way. It talks about representations.
Where's the finding that Mr. Dazi didn't intend that the equipment leases would be entered into or that the shares would be transferred in the SPVs?
I don't have an answer for you on those 2 points. I just have an answer for you on the Almheiri guarantee. Beyond what 58 says, insofar as what was said in the context of the Almheiri guarantee also applies in the context of the 2 other representations that were made.
But doesn't the yawning gap in relation to those 2 other representations suggest that in truth what was happening here was that the judge was saying the representation was false because it didn't come to pass.
No, I don't think that's what he's saying, and that's not what paragraph 20 of his order suggests at all. He goes back to 43, and he says, I was prepared to find that this was a representation, that was the then intention. That is a representation of fact which was untrue and was known to be untrue. So it's not simply a case of it not happening in the future, it not materializing, looking purely at did it happen, did it not happen, but also whether there was this sort of whether that was honestly held or not at the time. So whether Mr. Dazi honestly believed that Mr. Almheiri would be providing a guarantee. And then the judge's answer to that is at paragraph 20 of the order and says, no, that intention wasn't honestly held.
There would have been simpler ways of doing it.
There would be simpler ways, yes, but that is how His Excellency dealt with it.
This, with respect, is ingenious, but is it right?
It's a question for you, I'm afraid. That's 55, which I submit goes to the sort of procuring consent factor. Making someone accept something that isn't really what it is. That's just procuring consent, so persuading someone to do something. And then 61, he talks about this concept of being misled. Now, if you mislead someone, then that necessarily implies sort of that you effectively lied to them about something. That's what 61, he talks about misleading, that Mr. Cameron was misled into signing the indemnity agreement. And then if he hadn't been misled in the way that he was, so told that all these things would happen, he wouldn't have signed it. So it brings in this concept of misleading.
So where's the passage in 61 that?
Sorry, it's almost all the way at the bottom.
If he had not been misled as to the circumstances, yes, all right, he wouldn't have signed the agreement. Okay.
So when he's looking at misrepresentation in this context, he's looking at this concept of being misled.
Oh, this is in the context of the entire agreement clause. That's right.
It is, but it goes back to necessarily goes back to his findings on the misrepresentation or deceit. He talks about it in the context of being misled. Yeah. So if a party is misled into signing an agreement by someone else, that necessarily means, I submit, that something was said with a view to procuring someone's consent to something which isn't really what it is.
But that's exactly not right, is it? I mean, you can be misled by an innocent misrepresentation, which results in you signing a contract.
Well, it has to be deliberate, and the judge was very much alive to that requirement. If we go to 247 of the bundle, we can see what was going through the judge's mind as he was writing this judgment. So we'll start actually with the order with reasons of the judge. 247, he explains here what he was looking for. He says, I was looking to see whether there was deliberate material deception which induced the defendant to agree to enter into the indemnity. So two things here. He was looking for something deliberate, he was looking for something material, and he was looking for something that induced Mr. Cameron to sign the indemnity. Then he says, I concluded that there was.
Well, even then he doesn't say that there was a finding of intention. So there was a deliberate and material deception which had the fact of, but he doesn't actually, if we accept the submissions we put earlier about there having to be an intent to mislead, to come within Article 185, even in paragraph 18, he doesn't make that finding.
I think if you do something deliberately, you do it intentionally. I think that's the point here, deliberate material deception.
I see, all right.
And that is how our case was actually positioned. So paragraph 49 of the judgment, so we're going back to page 195. which is how sort of Glennie understood the case, which is 49, that's 195 of the bundle. One of the contracting parties, by words or representations made by him, procures the other's consent to something. So that's what he was looking at when he was looking at misleading or deception. So I think that does suggest to me, especially when read in the context of what His Excellency says in the subsequent order, that he was looking for whether something was said that procured Mr. Cameron's consent or misled him into signing this indemnity agreement. That's what he was looking for. And it's not sort of when we talk about this deliberate and material deception that the judge refers to in his order, it's not the first time that he refers to that. He also adopted a similar approach at trial. So page 1509. It's the top right-hand box, starting at line 16. And he says, doesn't the word trickery suggest some sort of deliberate misleading, which is very close to or maybe the same thing as dishonesty? And then respondent's counsel responds, it is. So he had that in his mind. That is what he was looking for when he was writing his judgment. And the appellant's counsel at trial shared exactly that same view when looking at the trickery requirement. That's at page 1517. This time we're looking at the box in the bottom left, lines 15 to 18. This is a submission from the appellant's counsel at trial. As your lordship recognizes, there was a word trickery in there, and therefore there would be something akin to dishonesty that is required under Article 185. So the judge and the parties are all operating on the same basis. It's common ground what the judge has to look for, what he has to find when considering deceit under 185. And we say that's reflected in the judgment at the paragraphs that I took you to. Read together, of course, with the order with reasons that was given. Now that's the first point of deception, and I did say I would take you to some cases to explain how deception is dealt with in case law. I'll start with Dubai Court of Cassation case 263 of 2022. That's page 2167. And then it's the third paragraph. It explains what deceit is. It starts with and whereas. And it says, according to Article 185, deceit is when one of the contracting parties misleads the other. So we saw in the judgment that His Excellency referred to Mr. Cameron being misled by fraudulent verbal or physical means. I'll come back to that, which causes them to consent to something they would not have accepted to without such deceit. And we looked at how His Excellency dealt with the fact that Mr. Cameron effectively he gave his consent to something in circumstances where he wouldn't otherwise have given it. So what we're really looking at is verbal physical means. What does that mean? Well, it means two things. You can have verbal deceit, which is mere statements or lies when you lie to someone. Or you can have physical deceit, which is an act intended to mislead. And that's where intention comes in terms of the act. It doesn't come in the context of verbal deceit, which is where you lie. So you're dishonest. That's that case, and a number of other cases.
Well, we were taken earlier to other authorities where there were 3 or 4 of them where it was said that an intent to mislead is an element of Article 185, whether it's verbally or by action. What you say we should read this as saying that the intent to mislead only applies to actions, not to words. And if so, what would be the policy underpinning that distinction?
Well, that's what this judgment says. I'll take you to other judgment. When it talks about acts intended to mislead, it doesn't talk about that in the context of verbal deceit. So it looks at
But
two
that's because an act has to have a quality. In other words, you can't just say an act. An act, you have to qualify the act to say it has to be an act intended to mislead, but surely the verbal deceit has to be intended to mislead as well, doesn't it?
It's not in that judgment, and it's not in any of the other judgments I could find in intention.
I'm not
in
sure.
the context.
Looking at the cases that we were shown earlier, but your whole case, as I understood it, which is why I asked you, is you accept that lying is a part, or is embedded in Article 185.
Yes,
And
dishonesty.
lying involves a deliberate intention to deceive. Now, unless you're going to tell me that that only applies to acts and not words, I thought that was the end of it.
So what 185?
Are you retreating from that?
Well, I've always said that deception, you have two ways. You can lie, so you're dishonest about what you're saying.
Yep.
With a view to procuring consent,
yep.
to giving someone, forcing someone to sign something which isn't really what it seems. That's verbal deceit.
Yeah.
That's dishonesty. You then have physical deceit, or deceit by deed, which is where you do something whereby you give a misleading impression. That's by doing something, not by conduct. Yeah.
Okay, but in both instances, which is why I've never bothered much with whether it's words or conduct, in both instances it requires an intention to deceive.
It's in a sense that you lie with a view to sort of misleading to get someone to do something that isn't really what it seems. That's how it's framed in the commentary to 265.
Well, we've seen that this morning. All the examples we looked at earlier suggest there has to be what I would call a mental element, or what the code has called a moral element. I thought you'd accepted that. That's why I'm intervening at this stage.
Well, the moral element is insofar as if you this talks about verbal deceit in the context of lying. So obviously you have to know that what you're saying isn't true.
Yeah.
So dishonesty.
Well,
but
then
if we talk
we're
about,
at one.
Sorry.
Then we are agreed.
Mm.
That is verbal deceit. Yes, you say something dishonestly, which induces someone else to enter into a contract. That's what this deception is. That's what the commentary we looked at earlier.
Sure.
Which is what's happened here in terms of verbal deceit. We're not looking at deceit by deed. So the definition that's given in the commentary is making somebody accept what is no good by lying. So you're dishonest about the truth of something, and you do that because you induce that person to effectively procure his consent in circumstances where had you told them the truth, they wouldn't have consented to it. That is how the commentary describes deception. And the means is simply either you lie or you do something whereby you intend to mislead. That's what this case says. And then there are, I think, 4 other cases which say exactly the same thing. So if we go to page 2080, because I'm very mindful of what the court has said in its letter, that unless it's something that's backed by authority, it's not going to make a finding of that, which is why I keep going back to the commentary and to the cases that need to be read alongside that. Because cases, there's no precedent, I'm sure, as the court knows. Cases will always say something slightly different. The benefit of the commentary is it draws all that together. And that's why I think it's so helpful to have that commentary at hand, in the same way that this court in Larmag did as well, when looking at what deception is. We obviously have cases, but we also have the commentary that we can refer to. This is another case. This is Dubai Court of Cassation case 36 of 2016. And it describes deceit in the following way. Deceit is where one of the contracting parties deceives the other by fraudulent means. So I said before, trickery can equally be read as fraudulent means, whether verbal or actual, which induces him to consent to that which he would not otherwise have consented to, which is sort of how the commentary to 265 describes it. Now you can do that by verbal misrepresentation, that is mere lying, or you can do it by actual misrepresentation, which is where you do an act whereby you intend to mislead the other as to the reality of something. So that's the same way that the other case looked at it.
But as Peter just covered with you, in both instances there has to be an intention to mislead, because lying is an intent to mislead.
That's not how the cases have described it, because it looks at the two different forms of deception: verbal deception, which is to lie, and physical deception, which is an act intended to mislead.
But
that's how the two forms.
But surely lying must carry with it an intention to mislead. You're making a statement that you know to be false. You must therefore be intending it to mislead, mustn't you?
You're making a statement which you know not to be true. That's exactly what verbal deceit is. Yes, that's how it's described. You're lying about something.
But you're really talking about expressive conduct, which can be manifested in by words or by deeds. If somebody is chasing a fugitive who happens to be a friend of yours and says, "Where'd he go?" You don't say anything, you just point in a particular direction, that's where he didn't go, then you can say that's a lie, but it's done by a deed. But it's all expressive conduct. I suspect the distinction is rather distracting.
Yes, I agree.
I think the examples that are given in the commentary are quite useful. You say the road is safe, but actually you know that it's full of thieves. So you know something that's not to be true, but you still say it. And there's some other useful examples which are given there. That's why I thought that commentary was quite helpful as a reference point to actually understand deception. Because with a lot of these cases, there's not a lot of facts. We don't actually know the facts of what's happened in this case. It's sort of a lot of the same wording that keeps being used of what deceit is. You have verbal deceit, you lie to someone, or you have physical deceit, you do something with the intention of misleading that person. But it has to be something that you know not to be true, because effectively what you're trying to do is you're trying to persuade someone to do something. You're procuring their consent in circumstances where you know that they otherwise wouldn't agree to it or give their consent if they know that not to be the case. And that's how we say the judge dealt with it in his judgment, in terms of looking at the representations which formed the basis of Mr. Cameron's understanding of how this would all work. That wasn't given honestly, and it wasn't given honestly because ultimately Dazi knew that if Mr. Cameron knew the truth, he wouldn't sign the indemnity agreement. There are a couple other cases. There's one at 2241. The very bottom of that page says deceit involves one party misleading the other through deceptive or physical methods, inducing consent to something they wouldn't otherwise have agreed to. That's another sort of definition of deception. I do have two other cases, but effectively it's repeating the same thing. One is at 2555. I should say these are cases that were cited in support of both the appellants and the respondents' submissions.
Yes.
Just the middle of that page, we see all those numbers, 185, 186, 187, 191. And it says all these articles indicate that deceit is that either contracting party would deceive the other contracting party by verbal or actual fraudulent means that will lead it to consent to what it would not otherwise have consented to. So that's again another description of what deception is. And then that same very similar description is given in another judgment at 2302. principles 5 and 6. Fraud or deceit that misleads one of the contracting party is achieved through verbal or physical deception. And it goes on to explain the rest. And then we looked at what verbal deception is, which is effectively a lie. And then at the beginning of that explanation, we see fraud or deceit that misleads. And I gave you the reference to where the judge referred to misleading Mr. Cameron in the judgment. So he was misled by what he had been told. So there's nothing in any of these cases. I think we cited 1, 2, 3, 5 cases about the court having to make any sort of separate or independent finding of trickery. And I'm not able to find any reference to any sort of finding of trickery that the court has to make, because that's how.
Sorry,
yes.
I'm being slow. Of course, you don't have to make another finding of trickery because you've already found it to establish deception.
Yes, that is the point. But the way
that's
that it was
your embedded point.
Yes, because the way that it was sort of formulated on appeal is that the judge didn't make a finding of trickery or gross cheat. I'll come on to gross cheat, but that's the point of trickery. That doesn't need to be a separate independent finding of trickery.
No, I mean the questions that are being put to you go to whether he found it at all, not that he didn't make some further finding of it.
That is how I understood that's how they presented the grounds of appeal. That there isn't a finding of trickery and that requirement is a mandatory requirement which is missing. But that's not a requirement. The requirement is deceit. And obviously to make that finding of deceit, we have to understand what deceit actually is. And we can see the different components of deceit and the findings that are relevant to that. We can see those reflected in the judgment. And I've walked through those different provisions of the judgment, which say, one, what Mr. Cameron was told when he signed, or before he signed the indemnity, was false. It was a lie. That's 43, 48, 56. The fact that Mr. Cameron was persuaded by Mr. Dazi to sign the indemnity, so his consent was procured through that lying or deceit. That's paragraph 55. And ultimately, the judge is finding that Mr. Cameron was misled into signing the indemnity agreement. And that's at paragraph 61. So those are the findings that the judge made and had to make. And then also another finding that he had to make when we look at 185 is a finding that it's not enough for Mr. Cameron to say, well, I was told all these things. But the judge also needs to make a finding that what Mr. Cameron had in fact been told actually induced him to sign the indemnity agreement in circumstances where he wouldn't otherwise have done so. And he does that at paragraph 55 of the judgment. That is at 197 of the bundle, where he explains that the representations were a material factor in persuading Mr. Cameron to sign the indemnity agreement, and that unless he had been assured that Mr. Imadi would sign an indemnity agreement, he wouldn't have agreed to the restructuring in those terms. One point I just want to add on this deceit is a point that is made by UAE cases, that ultimately the question of whether deceit occurred or not, so whether there was deceit or not in the circumstances, that is a matter of fact for the trial judge's discretion. That's at page 2602 of the bundle.
Well, I don't know. That's an issue of the approach that an appellate court takes to dealing with the decision of an inferior court. That's not covered by UAE law. That's covered by DIFC law.
Yes, so I was going to make the point. That same point is made in a recent DIFC Court of Appeal decision in Cristal. That's
Yes.
page 2683.
Yes.
And there the court was sort of talking about the extent of appellate interference in different circumstances.
Well, again, the question we're addressing here is not whether the judge made wrong findings. The question is whether he made necessary findings.
Yes.
If he did, then we're not interfering with his decision at all. If he didn't, then, well, then there's a problem.
Yes.
And on that subject, if we find that he didn't make the findings necessary to sustain his conclusion, what should we do? Should we send it back for a retrial, or what should we do?
Yeah, I was going to come on to that at the end. I think.
Well, all right. Let's deal with it at the end. That's fine.
Yeah. So I've walked through the judge's findings in terms of the different elements of deception of what he had to find. And he found not only that there was a lie, that lie persuaded Mr. Cameron to sign the agreement, the fact that Mr. Cameron was misled by what Mr. Dazi had said, but also the fact that what Mr. Cameron was told induced him ultimately to sign the agreement. That is 185. That's deception. But to escape a contract, it's not just enough to say, well, I was deceived. There is another requirement, and that is this aspect of the gross cheat, and that's in 187. So what does this gross cheat mean? Well, there's two cases which tell us what it means quite clearly. We've got Dubai Court of Cassation case 41 of 2024. That's at page 2242. The very top of that page, if deceit results in gross inequity, the deceived party may request contract annulment. Mere harm without gross inequity does not justify annulment. Then it says deceptive tactics, that's a deception, must be severe enough to affect the contracting party's decision. So must be severe enough to affect the contracting party's decision.
Well, the judge found that. So he found that if he'd known that Mr. Almheiri wasn't going to sign, he wouldn't have signed. So
yes,
there doesn't seem to be a particular problem with 187 then, does there?
Not in my view, no. I raised it because it was a point raised on appeal in terms of trickery and gross cheat. But if you're happy with gross cheat, I'm not going to keep laboring on the point.
Well, for my part, I think there's no challenge to the finding that but for the false impression that Almheiri was going to sign, he wouldn't have signed the indemnity, and that seems to be the requirement, satisfy the requirement of gross inequity. But if either of my colleagues thinks otherwise, then they can speak for themselves. All right. Well, I think in this area, you might be pushing at an open door, Mr. DeWolf.
Yeah, no, I will stop there then. That takes me to ground 3. Future promises and statements of present intent. We say there's no distinction in UAE law in terms of future promises and statements of present intent. There's no case or authority that was cited by the appellant that would suggest otherwise. And we looked earlier at what deception actually is in a way it's described at the commentary to 285. It's making a person accept something that isn't what it seems by lying and misleading means, which induces them to proceed in circumstances where they wouldn't have done so had they known the truth. So there's nothing in there about the tense of the deceptive conduct, and we say it isn't there.
It can't be a lie or a deception unless something more than a statement of something that would happen in the future that doesn't come to pass. There has to be something more than that for it to constitute a deception, doesn't there?
So if we look at this example where Dazi says Imadi is going to sign the guarantee, it would have to be that Dazi knew that not to be the case. So he was dishonest. He was lying.
So yes. So in other words, that Dazi knew that Imadi had said that he wouldn't sign the guarantee. So, but that's
not quite that Imadi had told him, just that he knew that it wasn't going to happen.
He knew that it wasn't going to happen. Well, then there's no material distinction then between present fact and future fact. If they know it to be false, it's the same thing. You say, well, we know it's not going to happen.
Yes, exactly. It's deception.
Right.
You can deceive someone with something that's going to happen, or you can deceive someone with something that has already happened, which you know hasn't happened.
Yeah.
And that's
the
exactly
complaint.
right.
The complaint in this case is that the judge hasn't found he has reduced the statements of future prediction into statements of present fact with respect to somebody's intention, but he hasn't found whose intention that was, or that the intention was not held. That's the complaint.
Yes, and we looked at that earlier in terms of how the judge dealt with it. That what Dazi had said effectively is, Mr. Cameron, Emadi is going to sign a guarantee. Don't worry. He also said that that's obviously something that's going to happen in the future, but it can very easily be rephrased as something that is then intention. So Dazi knew that Emadi wasn't going to give a guarantee, but he still said it because he knew that by saying it, Mr. Cameron would sign the indemnity. That's what we say the judge has found. And he clarified that point in his refusal in terms of granting permission at paragraph 20, where he says that was an intention. It was not honestly held. He knew it to be false, but he still said it.
Well, then haven't we already covered ground 3 in the course of covering ground 1? Well, but don't let me stop you. If you want to keep going, please do. But
yeah. No, I think it's the same points effectively.
Yes.
The very basic point is you make someone accept something by lying or misleading, and it doesn't matter whether that's something that has happened or something that is going to happen. And the question then is whether saying that something was deliberate and dishonest. And we say the judge was very much alive to that because he said at trial, this was before he wrote his judgment, that what he was looking for was something close to or maybe the same thing as dishonesty. So yes, I think we can skip over the rest and then we'll come on to the knowledge point, which is the 190 argument.
yes.
The starting point here is that it's not a point that was pleaded, and that should, we say, be the end of the matter. And the judge made that very same point at paragraph 24 of his order refusing permission to appeal. That's at page 248 of the bundle. So that should really be the end of it. It wasn't the point that was pleaded. But in any case, it's important that we distinguish between two different provisions here. We have 187, misrepresentation by a contracting party, and we have 190, which is misrepresentation by a third party. Now, the law makes that distinction because ultimately a contract is between the contracting parties. So it wouldn't be fair for one contracting party to say, well, this third party told me this, I was deceived into signing it, so therefore I want out. That wouldn't be fair. That's different, of course, if the other contracting party knew about what the third party had told the other contracting party, because he knows he would assume responsibility for it. That's sort of the interplay between 187, 190. But the situation is very different, where you have one contracting party that has effectively put someone else in the position to represent and speak for him, which is exactly what's happened here. Mr. Almheiri put Mr. Dazi in his position to speak for him, to take his place at the negotiating table. So in that sort of scenario, a contracting party can rely on what that representative says, because that's ultimately who he's dealing with is the other contracting party. And that's the whole point of ostensible authority.
Ms. Muller challenged you to identify an authority in which a person had been found liable under Article 185 for fraudulent statements made by an agent. Do you have such an authority?
I don't have such an authority. What I can give you is which I will be able to give you shortly once my colleague finds it, is a judgment which says that fraud by an agent binds the principle. So it doesn't matter in that circumstance what fraud that is. It doesn't matter whether it's an Article 190 scenario. It's ostensible authority as a doctrine. It doesn't have these sort of exceptions. Otherwise, you have a well-established and tried doctrine that has all these exceptions. We say that doesn't make sense. As a matter of logic, if you put someone in place to speak for you, you assume responsibility for what they do. And if they do something wrong, then you sue them. You don't blame the other party for relying on your agent. That's the point of sort of ostensible authority. And in terms of the criticism that was made, I think there was a suggestion of where this principle of UA law is actually established, where UA law establishes a recognized ostensible authority. And the court can find the reference to that in the appellant's skeleton argument for trial at page 1192.
And that's at paragraph 81.
Exactly, yes.
Right?
That's the supreme.
But the complaint then is, well, the judge didn't address the issues set out in that paragraph. And the further complaint is, well, you put different principles of law to the judge in your submissions, and the judge hasn't made clear which of the principles he has applied and what findings of fact he's made in order to find that there was authority.
Yeah, so we didn't put different principles. We agreed with those same principles. That's at page 1510.
Let me just pull that up.
Yeah. The box and the bottom right.
Sorry, which page?
1510. I think you were referred to this earlier. Line 5. Now the test for apparent authority is set out in the claimant's skeleton argument, paragraph 81. And then if we scroll over to the next page, this is page 90. I'm looking now at the page number of the transcript, not the bundle. Page 97 starts at line 16. We explain what that test is, and no issue was taken with that. It's a twofold test. We have the third party believing in good faith that the agent is authorized, and 2, there's an indication that the principal has granted authority to that agent. And then in terms of how that was presented to the judge, if we look at the tables that were shared this morning, table 2 deals with those 2 points with reference to the evidence, both in terms of documentary evidence and transcript evidence. So if we just look at those, an example of that evidence, I don't want to go into the evidence in great detail, but just an example, indication by the principal. That's 1124 of the bundle, where Mr. Cameron explains that he was told by Mr. Almheiri that Mr. Dazi would be managing the restructuring on his behalf. And he wasn't cross-examined on that point, as far as I'm aware. So that's an indication.
Where on that page? Whereabouts on that page?
Paragraph 27. Yes.
27, thank you.
In early 2014, Mr. Almheiri informed me that Mr. Dazi would be managing the restructuring on his behalf. So he was told in very certain terms, Mr. Dazi is going to be doing this for me. We then have, and I should say these references are all on the table that the judge had the benefit of. We then have the second requirement, which is the belief by Mr. Cameron, and that's at 1618. And here we have Mr. Cameron.
So what's the page number again, Mr. De Wolf? Sorry, what was the page number?
1618.
Thank you. Thank you.
And here we have Mr. Cameron negotiating the terms of his indemnity agreement with Mr. Almheiri, with Mr. Dazi. And Mr. Dazi speaks on behalf of Mr. Cameron. So, for example, not possible for my conversation with Cam. That's Khaled Almheiri. He would reject. One more sort of piece of evidence just to flavor the sort of what the judge was looking at and ultimately how he came to the conclusion that he did at paragraph 58 is that the appellant himself tells us in his evidence that he was instructing Mr. Dazi, and that's at 1116. We looked at that earlier.
Yeah.
Where he says, Mr. Cameron knew from Dazi and Mr. Ahmadi that Mr. Ahmadi would not be providing an indemnity and I requested Mr. Dazi to tell Mr. Cameron about it. He could have just told him himself, but he didn't because he had engaged Mr. Dazi to represent him throughout the course of that restructuring. So the principles were clear. The principles weren't an issue. The evidence was before the judge, and all that was left for the judge to do, therefore, was to make a fact finding. And that's exactly what he did at 56 in terms of a finding that Dazi was cloaked with authority to represent Mr. Almheiri. And just going back to the point about whether there is or isn't a judgment about ostensible authority applying to the 190 scenario, it would be very odd indeed if it were the case that Article 190 wouldn't apply in these circumstances, because the whole point of ostensible authority is to protect third parties in a sense that they don't have to verify a principal's knowledge or authorization. It would effectively amount to saying, well, yes, he had authority, but not for the purposes of Article 190. And we say that it just can't be right. It's a matter of logic. But it's not just sort of the respondent saying that. Actually, if we look at what the appellant has said at paragraph 8 of his skeleton, he concedes that Article 190 relates to true third-party statements, and Article 1.7 relates either to statements made by a contracting party or by someone else where those statements can be attributable to that party. That's page 79 of the bundle. So it seems to be a recognition by both parties. That's paragraph 8, very top there. That 187 is not just a case where it's the contracting party, but can also be someone who is an agent of the contracting party, in this case, Mr. Dazi.
Yes.
I think that deals with all the grounds that I am supposed to be dealing with, yes. And that just leaves the respondent's notice.
Yes.
Good.
Well, you've got 20 minutes for that, Mr. Dwarf, if you need it.
It should be very brief.
Yes.
Because it's really only sort of a fallback insofar as you're not with us on the other points. The first one is deceit. Now that's either a 185 scenario, so where Dazi knew that what he was saying was false, which is what we say the judge found on a sort of combined reading of the different provisions I took you to of the judgment and then read together with paragraph 20 of the order with reasons. If you're not with us on that, then we say that this court can make a finding on 187. So that's even where Dazi didn't know that when he said it wasn't true, he later learned the truth but didn't do anything about it. That's effectively 187.
No, 186. Not 187.
Sorry, 186. Yes, apologies.
186.
It is 186. 187 is the gross cheat one.
Yeah.
And we say that wouldn't involve the court making a new fact finding because it already has the admission from Khaled Almheiri, so the appellant, that he knew that Imadi would not be providing an indemnity and that he told Dazi about it, and crucially that he did so before Mr. Cameron signed the indemnity. And of course, we also have the timing finding, as it's called, of the judge, that Mr. Cameron himself didn't know the truth until November 2017. So that wouldn't require this court to make any findings of its own on the facts. That is that's deceit.
Sorry,
So,
I'm struggling a bit with that.
Yeah.
On the evidence you've shown us, on which the judge made no fact finding at all, as far as I can see, the page 1116. Mr. Almheiri did do something about it. He told Mr. Dazi to tell Mr. Cameron.
Yes.
So aren't you in a position on that it's either 187 or 190 or bust?
Well, it's so if we look at 187, that's where you know something, where you say something which you know not to be true, but which subsequently becomes untrue, and you don't say anything about it.
Sorry, forgive me. Forgive me. I think we've already covered 187 and 190. But if you don't get home on that, given your case, that we look at Mr. Almheiri's evidence and accept it, that he told Mr. Darcy to correct the wrong impression, I can't quite see how 186 arises.
Well, this evidence, the admission from Almheiri, shows that he knew the truth before Mr. Cameron signed it. He says, he didn't say he told Mr. Cameron, he said he told Darcy.
Yeah.
That's an issue between him and his agent, because it's something that Mr. Cameron wasn't told. So it was kept from Mr. Cameron. Mr. Cameron only found out in November 2017. So knowing something and not saying it, that's where 186 bites. And that's what this witness statement from Mr. Almheiri confirms. He knew it. He told Darcy to tell Mr. Cameron. But we know that Mr. Cameron was never told, and he didn't find out until November 2017.
Okay, but that then requires us to go into the facts to decide what Mr. Almheiri knew, what he told Mr. Darcy, and what Mr. Darcy did or didn't say.
Not quite, because it's an admission. So it wouldn't be a fact finding. It's the strongest form of a fact is an admission.
Not necessarily.
I don't know the authority off the top of my head, but I'm pretty sure there is an authority where it's not a fact finding insofar as it's an admission in a witness statement. So that wouldn't mean that the Court of Appeal would have to engage in a new fact finding exercise. It can make that finding on the basis of an admission given by a party. So that's where we say 186 comes in, because it's an admission by Almheiri. He knew, but Mr. Cameron didn't know until November 2017. So it was kept from Mr. Cameron. So it's one of two things. It's 185. It was known to be false. These representations were known to be false when they were made. Or it's 186, on the basis of the applicant's own admission that he knew the truth, but Mr. Cameron was never told. Now, the fact that Almheiri says, well, I told Darcy, that's not a defense, because we have to remember that Darcy is the representative of Mr. Almheiri here. So if Darcy doesn't do something, then that's an issue between the principal and the agent. It's not something that the principal can blame third party on, not something that the principal can blame on Mr. Cameron. That's the whole point of ostensible authority. So that's how 186 works, we say. When we're not into the 190, we're still in the 187 because we're still dealing with a representative or an agent of a principal. We're not dealing with the principal directly. And we say that doesn't require a fact finding because it's in the form of an admission in a witness statement. So obviously we wouldn't challenge that point. There's nothing to challenge. It's an admission that the court already has. And the other point that the court, of course, has to know as well, was Mr. Cameron told? And that is a fact finding that the judge made. So again, not a new fact finding that this court has to make. And the judge said that he didn't know, Mr. Cameron didn't know, until November 2017. So it must have been kept from him. And that's exactly where 186 comes in. The second point then is knowledge. Now, knowledge, as I said, it only applies if you're not with us on ostensible authority. So if you're not with us on that, then of course you have to look at 190. Then you have to look at, did the principal know? And then for the same reason, looking at the witness statement from the appellant, well, he tells us he knew, but he didn't tell Mr. Cameron about it. And Mr. Cameron didn't know until November 2017. So if you're not with us on 187, so on 187 and you're looking at 190, then 190 is satisfied as well without a new fact finding having to be made.
Well, the evidence you've taken us to shows that Mr. Almheiri was aware that Mr. Humaid wasn't going to sign, but it doesn't establish that he was aware that Mr. Darzi had told Mr. Cameron that Mr. Humaid was going to sign. Don't you need both for the purposes of 190?
Well, 190 is just actual knowledge. So 190 is you know that what someone was told wasn't true. So it's an obligation on you to correct it.
The point I'm making is the evidence, the judge expressly declined to find that Mr. Almheiri knew that Mr. Darzi had made a representation to the effect that Mr. Humaid was going to sign the guarantee. So the fact that the evidence you've taken us to doesn't go to that element. It goes only to the question of whether Mr. Almheiri knew that Mr. Humaid was not going to sign. You need both for 190, don't you?
See if I have the...
Because there has to be knowledge of the misrepresentation. So in other words, there has to be knowledge both that Darzi had told Cameron that Humaid was going to sign and that that was untrue. The evidence you've taken us to only establishes that Almheiri knew Humaid wasn't going to sign. It doesn't establish that he knew that Darzi had represented otherwise.
It does in not explicitly, but it does in a sense of why would you tell someone to tell someone something? You would only do that because you would have to have known that they were told something else before.
Well, I don't.
That's my reading of 73C.
Well, now you are asking us to find facts that the judge didn't find.
Again, the point is simply it's in a witness statement. It's an admission in effect that he knew before John Cameron signed that this wasn't going to be the case. He says he told Darzi. There's no evidence that Darzi told John Cameron. It is accepted that John Cameron didn't know until November 2017. And then I have to agree with you on that. It's not explicit. The fact that Mr. Almheiri knew that what Mr. Cameron had been told before wasn't true. It is implicit in a sense that why would you tell someone something if they weren't told something else before? It would have to be a correction. That looks at knowledge. And then we have ostensible authority. I mean, I've dealt with that point. The principles are obviously clear. They weren't contested. It was also not really a point that was raised in cross-examination. The only sort of question that Mr. Cameron was asked during cross-examination, that's at 1389 in the context of ostensible authority. So obviously, Mr. Cameron's evidence was, well, Mr. Almheiri told me that Darzi was representing him. He wasn't challenged on that. He was only challenged on this one point. And he was asked, Mr. Darzi, you mentioned, was acting for Almheiri, but actually he was acting for all the UBOs, wasn't he? And Mr. Cameron responds, no, he was representing Mr. Almheiri. That was made crystal clear to us all at the beginning. So there wasn't really much for the judge to engage with on ostensible authority. It wasn't something that was put to the judge in great detail by the appellant. It was not something that Mr. Cameron was cross-examined on before, apart from this one point. And so we say that the judge's approach in dealing with ostensible authority is simply reflective of the shape of the case that was presented to him. It wasn't a failure of reasoning. And that's really all the respondent's notice is. The primary argument we make is that the judge covered everything off. He dealt with the requirements of deception in different parts of the judgment. We walk through those different references in the way that he did, and we say that his reasoning or his approach can be, it's appropriate for that to be supplemented or amplified by what the judge said in his order dismissing permission for leave to appeal. But if you're not with us on that, then obviously this respondent's notice comes in those three respects that we looked at. So the 186, the knowledge aspect, and the ostensible authority aspect. I'm almost done. It's just the two more points to make. One is on the timing of the respondent's notice. I think there was an issue that was taken on that. It's quite a simple explanation.
Sorry, I can have to clarify. We don't take issue with that anymore.
Very well.
Yeah, right.
So
Thank
it
you.
leaves me with one last point, Your Honour, which is to respond to your question. What are we asking for the Court of Appeal to do if they're against us on everything? We say that a remission is more appropriate and proportionate than a retrial. A retrial is very much a measure of last resort. That's from the Court of Appeal decision in England, English and Emery, page 2214, paragraph 25.
Sorry, 2214. At paragraph
25. It starts from over the page, but then the relevant part sits just at the top of 2214. If he concludes that he has given adequate reasons, he will no doubt refuse. If an application of mission to appeal on the ground of lack of reasons is made to the appellate court and it appears to the appellate court that the application is well founded, it should consider adjourning the application and remitting the case to the trial judge with an invitation to provide additional reasons for his decisions, or where appropriate, his reasons for specific finding or findings. So that, we say, is the default position. And we say that because this is a very fact-heavy case. If the court looks at the tables in terms of the evidence that was before the judge, the cross-examination, examination of witnesses that took place, the volume of documentation, and the period of time over which this restructuring took place and the representations were made, there's no one better placed than the trial judge to make relevant determinations of fact than His Excellency. And more importantly, in terms of the approach that the judge took, we looked at the transcript. There was an agreement on what the judge had to find in terms of deception. It was all agreed between the parties and the judge of the relevant findings that he had to make. So there was no disagreement of the fact that the approach was wrong. It wasn't wrong. It's just a case at best of missing explanation in terms of the judgment. And we say that that can very easily be remedied cost effectively, preserving the benefit of the trial by an amplification of reasons rather than a full retrial. And that's something that is available to this court under the relevant practice direction at 44.1336. I'm conscious I owe you one more decision, which is on the fraud. And if I can come back to you on that at the end, rather than waste time now looking for it.
Yes, all right.
That would be very appreciated. Thank you.
Yes, thank you. Right now, who would like to reply?
I will reply. I'll be very brief in reply. Really, I was only intending to focus on one point on ostensible authority.
Yes.
And if we may please go to the bundle at page 1830, please. This is the Civil Code Articles 185 to 190.
Sorry, one page,
1830.
Yeah.
And what the point I'll be making here is that there's an important relationship between the various articles, which is relevant to a consideration of how ostensible authority would operate. The point that was in agreement between the parties at trial was that Article 190, when dealing with third parties, that can apply to instances where there's ostensible authority. That is where there's an appearance of having authority. 185 wouldn't apply in circumstances of ostensible authority. And the point that we made is there's no authority that suggests that 185 would apply in a circumstance of ostensible authority. Potentially an argument in the case of actual authority, but that's not the point that the respondent makes. And it's even more clear when one looks at the wording, not only of 185, but 187, which is that the contract, it says the contract was concluded by a gross cheat. And so the conclusion of the contract, so the focus there is not just on the word gross cheat, but the conclusion of the contract has to be by the gross cheat. And so it has to be Mr. Almheiri who was found to be a gross cheat.
No, it's by it's not a person. It's a cheat. It is a thing. It's an event. And the case has established that this is the remedy for the misrepresentation to which Article 185 refers. And the cases seem to establish that what is meant by gross cheat is that the person who was misled was cheated out of something substantial, something of value. There was a gross inequity.
Yes, I think the only point I make when tying in 187 and 185 is that there's from the wording of those provisions, there's no way to interpret those in circumstances where Mr. Almheiri wouldn't have knowledge and have understood that Mr. Dazi was making representations on his behalf which were inaccurate. Because the interpretation, and I'll make one point which I think perhaps illustrates this. If the respondent's position is correct, that would really defeat 190, which requires knowledge.
Well, the respondent says that 190, and they rely upon your paragraph 8 of your skeleton for this proposition, 190 deals with third parties. An agent is not a third party. An agent is, if you like, acts in the place of the party. And so therefore, 185 applies in the case of deception by an agent.
Well, I think the point I make firstly that if it's actual agent, then it's actual authority, not ostensible.
But why wouldn't ostensible authority? If you clothe somebody with authority and say, Mr. Dazi, don't talk to me, talk to Mr. Dazi, that's ostensible authority, isn't it?
Yes, but well, I think that is arguable whether that's actual or ostensible. But if we remove the knowledge requirement, in that what's relevant is that Mr. Dazi gave the appearance of being an agent of Mr. Almheiri, that would suggest wouldn't engage 185 in particularly when looking at the fact that it has to be the contracting parties, one of whom has to deceive the other. The intent element would also then be something that the contracting party wouldn't have the intent. That would also be the Mr. Dazi's intent, which would then be relevant. There's no authority to support that interpretation of 185. But it's difficult to see a scenario in which, if that interpretation is correct, and that removes the knowledge requirement, so 185 doesn't require knowledge, 190 does. Then in fact, what it does is that 185, the scope of 185 is broadened to such an extent that I think it really, I struggle to see a scenario in which 190 then is needed with the knowledge requirement of 190.
Well, it'd be where somebody goes to somebody else and says, a third party altogether, and says, what can this land be used for? And the third party goes to a town planner who's not the agent of the vendor and says, what can the land be used for? And he says it can be used for, I don't know, a hotel. And the vendor knows that representation's been made and doesn't correct it, then that's when 190 would apply, wouldn't it?
Well, I won't push the point. I think my interpretation of 190 is that because it requires knowledge of the misrepresentation, and because it's a third party who the representation has to be known to Mr. Almheiri, to the contracting party.
I mean, just one heretical question for me. Why would a contracting party need to bother about some misrepresentation by some total stranger? Which may mean that 190 has a slightly narrower scope, which may also mean we want to steer clear of getting involved in a deep-seated study of 190 and 187.
Absolutely. One thing that I think the position we're in, and the reason we put it the way we do, is that what the court has before it is the wordings of these provisions. There isn't any authority to suggest that just looking at the wording of 185 specifically, when it refers to the two contracting parties, one of whom has to deceive the other. There's nothing in the wording of that that would suggest that would extend beyond the party itself. And to the extent that the respondent suggests it does, it would need to provide an authority that supports that.
Well, as the Chief Justice says, an agent certainly one with authority fits naturally into that definition, as the Chief Justice has said.
Yes, I think we can accept is that if it was an agent, there isn't any case law on this, but an agent with actual authority, arguably yes, that would fall within 185. But whether one with ostensible authority, but they don't have actual authority, which is the basis on which the respondent's case was put, and we went through the transcripts, how the legal test was set out for 185. That we say wouldn't be the correct gateway for that. And finally, I will conclude with just the point on whether there should be a remission or a retrial. For the reason that might be obvious, we've already gone through at some length some of the wholesale absence of factual findings, including whose intention, who knew, whether the person who held that intention knew it was false at the time, whether the representing party knew the intention was not held. All of those are quite significant factual findings that warrant a retrial. And we would suggest that had the respondent pleaded its case fully and properly, as they now seek to elaborate on appeal, all of these are matters that really require a cross-examination and going back to the witnesses to give evidence on these crucial issues, on which there's an entirely absence of any factual findings.
Yes, thank you.
Thank you. Unless I can assist any further, those are my...
No, thank you, Mr. Solomon. Now, Mr. De Wolf, have you found that authority about the party being bound by the fraud of his agent?
Yes, so it was in a table that was submitted to the court during the course of trial. We're trying to track down the authority, but we found the table which references the authority, which is Dubai Court of Cassation case number 141 of 2006. So we're just trying to track down the email in which that case was sent to the court, because it's not in the bundle.
All right.
So once we have that.
Court of Cassation case 146.
141 of 2006.
141 of 2006.
Why didn't you send us a PDF?
Yes. If you could send the court a PDF, and that court can circulate it to the judges.
Okay. Do you need the table as well, where that appears?
No,
that was
no,
just
no,
the case.
I don't think so. Just the case will be sufficient.
Okay.
Well, perhaps you send the table as well. That might be a good thing to do too.
Okay.
All right. Well, I think that concludes the hearing then, unless there is anything more. Obviously, we'll need to reserve our decision, and we'll give our reasons as soon as we can. But it's obviously a complex case. It's going to take us a little while to prepare reasons, so we'll do the best we can in that regard. Unless there's anything else, the hearing will now be adjourned, and the judges will return to our separate link. All right. Thank you, everybody. Thank you for your
very
assistance.
much. Thank you very much. Appreciate it.